Yes, the state also does have a motion to eliminate or 6 short.
We'll get to that. I just wanted to not too much time. You're ready to go with your questionnaires and do some other things.
If I just have like 2 or 3 more minutes, I'm almost done.
Okay. I just have a question. Ms. Matthew, I noticed that you had filed an amended notice of discovery. Not sure if you added a witness or did you just add a additional piece of paper?
Your Honor, we did add an additional witness, and we did make Ms. Wilson aware of this on Monday morning after we got out of court. And we don't intend to call this witness unless it's for rebuttal purposes, should the defendant do the stand.
Who is that person?
That is Christy McLaughlin with the Collier County Sheriff's Office.
McLaughlin?
Yes, it's McLaughlin.
We figure out 600 was?
Yes, sir, it was Mr. Marrero. I believe it's your number 11.
Sure.
Ready to move?
I'm ready on.
All right. Battery, you ready?
Yes, sir.
All right, suggest your motion.
Yes, sir. Your Honor, case, motion order number one, still representing the website, in the trial, and, as we mentioned, as I mentioned, we did supposed to witness, earlier this week, so she has called, as much as you are from, making any reference, there's brief, and there's some sort of speculation why she wasn't called stuff like.
Mr. Wilson, you should.
No objection.
One, correct? Two.
Your Honor, and then two, just, the defense will be precluded from making any difference, this is the defendant's most important day, in his life, and his liberties at stake.
No objection.
Two will be granted. Three.
And in this case, Your Honor, there is no, video recording or anything that occurred, so, again, pursuant to case law, there is no duty for law enforcement to actually record any type of criminal incident or transaction that occurred.
No objection.
Three will be granted. Number four.
And then number four, Your Honor, the state just requested that there's, you mentioned that the reason for the stop was unlawful. There was two reasons for the stop, speeding as well as a non-functioning taillight, and any such argument against an unlawful stop, speed on motion is strictly brought via English.
Wilson.
No objection.
The floor would be granted. Just to clear up the record as far as the added witnesses, Wilson, any objection concerning that as far as the discovery issue?
No objection, no.
All right, you're ready for the jury, then?
Yes, Your Honor.
Anything else I need to know? Oh, yeah, I do want to ask you one thing. Can I tell them something will be one day?
Yes.
Do we need to have an alternate?
Yeah, I think one day on.
Do we need to have an alternate? Do we trust it to walk back?
The state would request an alternate.
But so with the defense, Your Honor.
I'll take it. Okay.
Next one is, you have to before.
Yes, Your Honor, the trial is scheduled for tomorrow, we won't be needing a jury trial, a jury pool, the defendant's going to be accepted.
Okay, thank you. All right, so these guys are all.
And he will be present tomorrow to enter into that.
No, I understand that, I understand. Okay, let's get into the jury.
Your Honor, the jury poll.
One second. Yellow dot right there. That yellow dot's right there. There you go.
Yeah.
You see. See them. Sorry.
All right, you may be seated. Good morning, ladies and gentlemen. I'll have to learn how to project my voice now. It's been a while. It's tough to do with a mask on. But I want to welcome you to Collier County Court this morning. We do have a case for you to hear. I do have some instructions that I'll read to you. Some of them are pretty much tailored based upon the circumstances that we find ourselves in now, and they are a little bit different. I just wanted to let you know that because we do reduce the number of people who appear in the courtroom, that we will we record these speech. Actually, we are broadcasting these proceedings. There is a camera there, as you can see. That is not going to face on you, so that you can be rest assured that no one will know, at least as far as seeing your face on YouTube at this point in time. Unless you put out your own videos, you're free to do that. In any event, we also will, as you can see, conduct as best we can, keeping our social distance, and the masks that you are wearing are only for the purposes of this word dial proceeding. Where you are being selected is whether or not you're going to be a juror or not. After that point in time, you'll be able to wear whatever you brought in, or if you did not bring one in, I'm assuming they gave you one at the door, if you'll keep that. So throughout the proceedings, again, if you will, make sure you do practice the social distancing as well as wearing your mask. It's been very difficult for us in these pandemic times. We may seem a little rusty. It's been about a year, actually a little over a year, since I last had a jury trial. So we're learning as we go along to try to make things better for you. If there is an issue that comes up, please let the bailiffs know. They'll try to let me know and see if we can correct it. Afterwards, if you have any suggestions, we would welcome those if you let us know somehow to make it better. You are our guest here, that's why I'll have you sit. We stand for you during the proceedings. And just so whenever you come back into the courtroom, you're free to sit as soon as you can. And notice that the majority of you have not served on a jury before. Those of you that have, this probably looks a little bit different. Mr. Bundage, where are you, sir? There you are. Okay. You said sometime back in the 90s. So obviously different for you, different for us. Other little things that are different. Back in the 90s, I think there probably was a court reporter that was sitting here taking down what was said. Now we have the microphones, things are electronically recorded. The important part about that is the fact that when you are asked a question during this word dial process, if you will answer out loudly, you don't have to yell hopefully as loud as I am, but there are microphones that will pick it up. If you just nod your head, no one will know what you have to say. Also, the other issue is sometimes we get a little tired. I know we have some school teachers here, and they hear mama and mama a lot, and that necessarily is difficult to tell, especially now with a mask on your face, what that means. So yes or no is a lot better. It also would help if this ever gets transcribed, that individual who has to listen to it to actually figure out what it is that was being said. Okay? Good news is that we anticipate, and I say that anticipate because things change and things go a little slower now because we do cleaning after every witness and wiping down the podiums and the seats and that sort of thing. We do anticipate that we'll be finished today. So hopefully that will put your mind at ease on that. I also noticed that we do have a number of people that have children in school. Let's see, Ms. Jerome, Ms. Rothman, and Clydesdale. Any issues, if we were to go to 5 o'clock today, is that going to be a problem as far as child care?
No.
Oh, so we're going to allocate care for today?
Yes.
All right, perfect. And anyone else have any elderly care or any other child care that I don't know about that would prevent them from being here all the way until 5 o'clock today? Okay, perfect. Today's trial is the state of Florida versus Nicholas Allen. Mr. Allen is charged with the crime of resisting or obstructing an officer without violence. Again, I'll explain to you what that is and what the elements of that particular offense is at a later point in time. I was here, so I'll indicate that I was here when you were sworn in as jurors. Is that correct? You may not have seen me.
Yes.
Okay, but you were sworn in, is that right?
Yes.
All right. And State, are you ready to proceed?
Yes, sir.
And defense?
Yes, Your Honor.
And just to introduce you to the individuals that you'll be seeing here throughout the proceedings. Some of you have been bailiffs. Again, they do assist me throughout the course of the trial. Anything that comes up that you need, let them know. It's slowly getting into summertime. We kind of have wetter, dry seasons more than summertime, winter, spring. But in any event, we may get back in spring again this weekend, but then it'll go summer again next week. So, but in any event, I can't do anything about the temperature in the room. It's controlled throughout the whole floor. So don't ask if you're too cold or you're too hot. If we take a break and you've got a sweater or something out in the car, you can go ahead and get that, use that, and we'll see what we can do. But if we change the temperature in the setting, probably tomorrow you'll notice a difference, and hopefully we're not going to be here for that anyway. Okay. The other aspect of this is lost my train of thought. See, I'm out of practice. I'm sorry. I apologize if I do that. Let me just ask you this: anyone on the jury panel know anybody else on the jury panel? Okay, so I have. Let me see. Is it Miss Starkweather?
Yes.
And Miss Clydesdale?
Yes.
And is that, how is that? From school?
Yeah. School, church.
Okay, church, all right. Anything about that relationship that would prevent each of you from being an independent juror as far as making up your mind?
No.
Anyone else? The other individuals that were here, that's where my train of thought dropped off, was for the state, we have Ms. Matrino and Mr. Rao. They'll have an opportunity to introduce themselves to you later. And Mr. Wilson and Mr. Darrow are representing Mr. Allen. And anybody know any of those individuals?
No.
Anybody know myself? All right. There are potential witnesses that may be called in this particular case. Jason Booth, Clark County Sheriff's Office. Anybody know Mr. Booth?
No.
Anybody know Miss Christy McLaughlin, also with Clark County Sheriff's Office?
No.
Mr. Lesher? Having a hard time. Yeah, how you doing as far as hearing me at this point in time? Okay, so okay. As the video that you saw earlier today indicates what your job is that you're going to try the facts of this case. So it's important that you hear everything that goes on. If after we do this selection, you'll be placed in the jury box, you'll be separated out, socially distanced. But if during the course of the trial, from the witness stand, if somebody says something or the attorney says something that you don't hear, it's perfectly fine for you to raise your hand and say, could you repeat that? Could you speak louder? Okay, so you're free to do that during the course of the trial, all right? The other part is if there comes, of course, during the trial, I'll try to take a break after every witness time, or natural breaks whenever we can do that, unless it's, you know, in 5 to 10 minutes, but we won't. But generally every hour if we can. But if there comes a time that you need a break, just raise your hand and I will, I want to make sure I turn on the microphone. I forgot about that. We'll take a break whenever we need for your comfort, okay? Deciding the facts of the case then is going to be exclusively your job. And then what I will do is I will tell you what the law is in the state of Florida. Some of you are come here from another state. Some of you may have tried a jury trial in another state. Some of you may have watched TV occasionally, seen some crime shows, maybe read a book about it, and have some idea what you think the law is. There are certain, if you come from a northeastern state, generally if you're a common law state, sometimes you'll run into something that you hear on TV as assault and battery. And that's one crime in those particular states. And if you come down to Florida, we have a crime called assault. We have a crime called battery. They're two separate crimes and two separate evidences or requirements of proof. The other big thing you see on TV is the lady comes running out of her house and the cops show up in the driveway and she says, I've been robbed, I've been robbed. And they go in, they say, what happened? She was like, I came home and all my stuff is missing. Were you there? No, I wasn't. So technically, at least in the state of Florida, she has not been robbed. Her house has been burglarized. Now, if she was home and somebody was there when that happened, then there is a robbery. A robbery is a personal crime. A burglary is a property crime. There is a difference. So those are the distinctions that you may or may not know. And the reason that I point those out to you is because I want you to forget all about that. All right, as best you can. I want you to apply the law that I tell you what the law is in the state of Florida. Can you all do that?
Yes.
Can you do that even if you think, are you kidding me? This is the law in the state of Florida? Can you do that?
Yes.
You understand that we don't change the law here in the courtroom. The law gets changed in Tallahassee. If you don't like it, those are the people that you have to get changed. I can't change it. I'm bound. I took an oath to abide by the laws and to uphold the laws of the state of Florida. And you as jurors took the same oath to do that too. So we don't get to change the law here in the court. The other part about that is I will tell you what the law is, and then you decide, do the facts that we find, do they constitute a violation of that law? If you do, then it's your obligation to come back with a verdict of guilty. If you have a reasonable doubt whether or not those facts constitute a violation of the law, then you come back with a verdict of not guilty. So no one's going to ask you to question whether or not Mr. Allen is a good or a bad person. The question is, did on this particular day, and you'll hear basically this is a historical recitation of the facts that occurred, that do those facts constitute a violation? We're not asking you to sit in judgment on Mr. Allen. All right, anyone? So that being said, there are still some individuals who say, because of my religious beliefs, I do not want to sit here as a juror. Anybody have those particular holdings? Okay. I was going to bring something up, but I'll skip that because there is a jury instruction that will cover that issue. I trust that you will all follow that instruction that I give you. The only other thing I want to do at this time is to make sure that when we're talking to everyone, that we're talking to the individuals that we think we are. So, if I could, I have Mr. Glass Cruz, Mr. Hayes, Election. Ms. Smith? Oh, I'm sorry, Mr. Douglas. My depth perception changes sometimes with the benches and hard to tell. Let's see, then we have Mark Joseph. Ms. Jerome. Ms. Dopinger. There you are. Howard, Ms. Howard. Ms. Rothing. Starkville. Or is it Marrero? Clydesdale. And Antonacio? Is that how you pronounce it? That is correct. August? The front. Shukulu?
Shikala.
Say that again one more time.
Shikala.
Parr. Ms. Haddon. Perfect. All right, with that, then I will lead you with the state and have an opportunity to address you. I do want to, and this is one of the stages, actually the only stage of the trial where you'll have an opportunity to have a discussion with the attorneys. Once you get selected as a juror, basically everything gets told to you. You listen to the witnesses, you listen to the closing statements, you listen to the court giving you instructions as to the law at the end. So here you get a chance to have a discourse back and forth, and I just request that you take advantage of it as much as you can. It does help the attorneys make a decision as to who they feel would be a proper juror in this case. Keep in mind that if you're not selected, that doesn't mean they don't think you'd be a good juror. It may simply mean that it may not for this particular case. Okay? All right. Thank you. It's back to
Will you please the court, counsel, members of the jury pool. Good morning. Can I get a raise of hand of who was super excited when they found out they had to report today for jury day? Yes, I've got two. Awesome. That's the first time I get two. I've had one before. And then I've had a few where it's just awkward silence for a second or two. So as the judge mentioned, my name is Lorena Matrino and I represent the state of Florida and the residents of Collier County, along with my co-counsel, Mr. Lawrence Rapp. And we want to take this time briefly to give you our thanks for being here present. I know we appreciated the court, defense counsel, and the defendant as well, especially during these very exceptional circumstances that we're living in the middle of a pandemic. And we can't do our job if we don't have you guys show up. So thank you for showing up this morning. And as the judge mentioned, the purpose of jury selection is to select jurors that are appropriate for this specific case. So in order to do that, I hope we're able to engage in a flowing and open conversation this morning. And that means if you want to interrupt me because you don't understand something, or you want me to rephrase the question, or you want to say, okay, well, what about this? Go ahead and do that. Please raise your hand. Please feel free to speak up. And it's okay if your opinion is different from the person sitting to your right or sitting to your left, because we've all had different life experiences, and we all look at a certain situation differently. And that's what makes us different and unique. And that's good. That's a good thing. So before we get talking into a few things such as elements, very quickly, can everybody hear me? Am I speaking loud enough for everyone? Okay. And everyone has understood the judge up to this point and myself?
Yes.
Yes? Okay. Mr. Cruz, I did notice on your questionnaire, you did check off that you read and write the English language, but you didn't check off speak and understand.
No.
You don't understand it? You have a hard time understanding the English language?
I understand some things, but no.
Okay, so some things you understand and some things you're having difficulty with? Okay. And so you think that's going to affect your ability to sit here today, if you're selected as a juror to listen to witnesses, to listen to testimony, with your limited understanding? Okay. Perfect. And is there anyone else that's having a hard time understanding maybe what's been going on or what may go forward? Okay. And before I start, if I butcher your last name, please do correct me. Okay, this happened to me many times. My first and my last name, we butcher it. So please correct me, and I will try my best to correct it. Now, I know the judge briefly mentioned or asked you guys if anybody had some sort of disability that would prevent them from sitting here today. I didn't see any hands being raised. Is there any outside concerns or a situation maybe you're going or a family member's going through that's so daunting that you won't be able to focus if you're selected as a juror here today?
He did. I'm sorry.
Mr. Joseph?
Yeah, I didn't hear the judge say, ask about disabilities, but I did write on the
Yes.
an illness I had, but I don't know that it'll affect my ability to be able to sit here today.
Okay, because you've got
I put maybe on there. There wasn't a box for maybe, so I just ruled it in.
maybe. And do you have any idea what would maybe affect your ability, or does it kind of?
I mean, it depends.
Okay.
It depends. There's various circumstances that can set it off, so it's not. I could tell you I probably would be fine.
Okay. You probably would be fine. And are you on any type of medication for?
No.
Okay. And you would have no problem sitting here if it's like the judge mentioned, a one-day trial, maybe 5 or a little bit past 5?
I should be fine.
You should be fine. Anyone else have some sort of medical condition or anything else they may be concerned about today? Now, reasonable doubt. How many of us have heard that word before? Okay, quite a few. I know the judge is going to later on instruct you on the definition of reasonable doubt. And he's going to tell you that the state has the burden today to prove the crime that the defendant's charged with beyond a reasonable doubt. So who here can tell me what they think reasonable doubt means? Mr. Joseph, because I do see you're an attorney, correct?
Mm-hmm. Yep.
And what type of law do you practice?
Well, right now I'm doing commercial, PIP, transactional work. I've done a little PI. And I've got one criminal case with a minor, but it's not my thing. It's definitely not my thing.
So you don't normally practice criminal law?
No, I don't normally practice criminal law. This one just kind of fell in my lap because partners didn't want to handle it, so.
Okay.
Yeah.
Stuck you with it.
Stuck me with it.
And so does the firm you work for typically handle criminal?
They do not.
They do not?
1 or 2 partners have in the past practiced criminal law, but they don't.
You don't normally just practice it. Okay. And does the fact that you're handling this one criminal case, would that affect your ability to sit here today as if you're an impartial juror, given the fact that this is a criminal case?
No, I'm not particular to criminal law, but that's practicing the law. I do find sitting as a juror, yeah.
Mr. Hayes,
Yes.
what do you think reasonable doubt means?
Reasonable doubt would be that if the state didn't prove to me that you committed a crime, if there's something in there that maybe I didn't agree with or something, or it was doubtful that you did it.
Okay. And you say it was doubtful. Does that mean your doubt has to be against all doubt?
Yes.
Okay, you think it has to be against all doubt. So let me give you guys a hypo real quick. So, Mr. Rose, you've got small kids, correct? Jerome, you've got small kids.
Yes, I do.
So you're at home, and you're baking cookies for your kids. It's a Saturday evening, and you just made cookies, and you just took a fresh wrap of cookies out of the oven. And then your doorbell rings. When you get back from answering the front door, you walk into the kitchen, and you see that one cookie is missing. Then you see your child standing next to the kitchen island. And standing there with his hands behind his back. He's got little crumbs on his shirt. He's got a little bit of chocolate on the corner of his mouth. And his cheeks are bulging. What do you think happened? She took the cookie. Mr. Lesser, what do you think happened?
Well, she was answering the door, you got a cookie.
Who got a cookie?
The child.
The child ate the cookie. And Mr. Smith, do you agree with that?
Yes.
What about you, Miss Stockinger?
I believe the child ate the cookie. Or is in the process.
Of eating the cookie. Now, Miss Howard, what if I told you that next door lives a child like Dennis the Menace? And that when you walked to your front door to open that front door, that teenage boy came in, took the cookie, ate it, put some crumbs on Mr. Rome's child, smothered a little bit of chocolate on his corners, and said, stand there, your cheeks bulging, or I'm going to come back and break your favorite toy. Is that possible?
The next door neighbor boy came into the house
Yes.
and also had crumbs in his face.
And that while Mr. Rome was answering the door, the boy ate the cookie.
The little boy.
Nope, the teenager from next door. And he so-called framed Mr. Rome's son. Put little crumbs on Mr. Rome's son's shirt, put little chocolate on the corner of his mouth, and said, stand there with your cheeks bulging, or I'm going to come back later and break your favorite toy. Do you think that's possible? But is it reasonable?
Probably not.
Mr. Marrero, do you agree with Ms. Howard?
I think that's right.
Do you agree with Ms. Howard?
What?
Do you agree with Ms. Howard?
Okay.
Did you hear what Ms. Howard said?
Yeah.
Okay.
I hear her, but I don't understand exactly what you know. It's difficult to understand for me. So I'm so far away.
Yeah, it's a little difficult.
Yeah, it's difficult.
I don't get 100% of it.
Okay. Okay, that's fine. You can,
I mean,
I drive to this thing here.
okay, so you're having difficulty here because we're not using this microphone, or do you understand the English language and everything? Do you understand the English language?
Yeah.
Okay. All right. So, Mr. Marr, what I asked Ms. Howard was, the next door neighbor, there's a teenage boy, kind of like Dennis the Menace. So he comes in to Mr. Rome's house while Mr. Rome goes to the door to answer the doorbell. And he comes in and he grabs a cookie and he eats it. And he then proceeds to put crumbs on Mr. Rome's child on his shirt. And he smears a little chocolate on the child's corners of his mouth. And he says, stand there with your cheeks bulging out, or I'm going to come back and break your favorite toy. Don't tell your mom I took the cookie. Do you think that's possible? Do you think it's possible? No? You don't think it's possible? It's not reasonable, correct? Is there anybody here that disagrees with that? Yes, Mr. Joseph.
I think it depends I mean, if you're saying that those are all the facts, then it's probably not reasonable, but obviously questions are asked and it turns out that he has a history, the next door neighbor has a history of coming over to the house, eating the cookies, or mom is away at the door for like 10 minutes, and there's a possibility that next door neighbor could have come over to the house and laid out this scenario. I think it's possible, yes, and I think it could be reasonable depending on the history, but you'd have to have more facts.
Okay, so you want more information?
Yeah.
Okay. Mr. Marrero, you're shaking your head back there. You're shaking your head back there as Mr. Joseph was speaking. You can't hear me still?
Say it again, please.
I said you were shaking your head back there like no, as Mr. Joseph was speaking. Do you disagree with Mr. Joseph?
You know, this is important. And then he's going to our house.
I'm sorry, what was that?
I say this. I
Like,
don't know.
you don't know what's kind of going on right now? You're having difficulty understanding?
I understand that. When the kids go to our house,
What was that?
I say that I don't understand how one kid go to our house and get a cookie, such a different one.
You don't think
Something like that.
you don't think it's reasonable? Possible but not reasonable?
It's possible.
Okay. Is there anybody that agrees with Mr. Joseph? Or do we all think that it's possible, but it's not a reasonable circumstance? So that's kind of the definition of reasonable doubt, which I will read to you. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. So in that situation, it's very possible, but it's not a reasonable doubt. So you're allowed to have doubts in this case. They just must be reasonable in order for you to find the defendant not guilty. Does everybody understand that? Everybody understand that? And is there anybody here that is going to require the state to prove this case beyond all doubt? Nobody? I don't see any hands or heads shaking. Now, let's talk about elements of a crime. So the state has the burden to prove all the elements of a crime beyond a reasonable doubt. So now, Ms. Rothring, if I tell you that the law in Florida, I'll give you a hypo, the law in Florida is that it's illegal to have a pen in the courtroom, what are the things that I have to prove? Okay, so I have to prove one, that I have a pen, and what else?
That it breaks the law.
And it breaks the law because this pen is in the courtroom. So would you agree that I would have to prove two things? That that person had a pen and that person was in the courtroom?
Yes.
And you would then determine that the state has proven its case beyond a reasonable doubt?
Yes.
And Ms. Starkweather? Good morning. Would you agree with Ms. Rothring?
Yes.
That I have to prove two things?
Yes.
That I had a pen and that I was in a courtroom? Ms. Clydesdale? Do you also agree?
Yes.
That's
Mr. Intasio?
nasty.
Antonesio? Would you, if I present you with evidence and testimony today that says I had a pen and I was in a park, has the statement that it's burden of proof?
No.
Why not?
You didn't prove you were in court.
Correct. Mr. August. Would you also agree with Mr. Antonesio that if I presented you witnesses and evidence today that I had a pen and I was in a park, that the state hasn't met its burden? I'm sorry?
I don't think so.
Okay, and why don't you think so?
I think relevant to a courtroom, not in a courtroom.
Correct, because the law is that I can't have a pen in the courtroom.
Doesn't prove that it doesn't prove whose pen it is.
Okay, so you'd want to know whose pen it is?
Right. How do you print something like that? Anybody can help a pen at any time.
Okay. It's a great point. Did the two elements that Ms. Rothinger and Ms. Starkweather pointed out say that the state had to prove who the pen belonged to?
Honestly, I don't remember what you said.
I'm sorry?
Honestly, I don't remember what you said.
So the two elements that the state has to prove is that I had a pen and I was in a courtroom. Would you agree with that?
Sure.
And if the state proves that, then I've proven that I broke the law.
I suppose. I suppose.
And I don't need to prove who the pen belonged to because that's not an element of the crime, correct?
I think you prove that, I think you need to rule out that the pen belonged to somebody.
Okay, so you'd want to know who the pen belonged to.
Sure.
So you'd hold the state at a higher burden.
I would.
You would?
Yes.
Okay. And Mr. Brennan? What about you? Do you agree with Mr. August or you disagree with them?
I tend to agree with them. I'd like to see other evidence, perhaps like fingerprints on the pen and who the fingerprints belong to. It could be other forensic information too that would raise it now.
Okay, so you would want to know, as Mr. August, who this pen belonged to?
Yep.
Okay. Even though the law is, if somebody has a pen in a courtroom, they broke in Florida law.
Well, someone could have had a pen in the courtroom, they dropped it, someone else picks it up, and they get blamed with that crime, and I don't think that would be fair.
And you don't think that would be fair? Even though if they picked it up, they then are in a courtroom with the pen.
Yeah, I think the intent was that, it wasn't their pen, they saw it before they picked it up.
Okay, so you want the state to prove intent, that you intended to pick up that pen in a courtroom and therefore purposely broke the law.
Yeah.
Okay, and from the two elements that Ms. Rothringer and Ms. Starkweather mentioned, did the state have to prove intent?
I believe so.
Okay. So the two elements are, I have to prove that there was a pen and it was in a courtroom.
If you intended to bring it, and you did that to the court.
Is that an element that I said is part of the crime?
I believe so.
Is there anybody that agrees with Mr. Brundage? No one? So, Mr. Brundage, you wouldn't be able to follow the law as told to you by the judge, which in this case, in our hypothetical, would be that all the state has to prove is that there's a pen in a courtroom. Doesn't matter who's holding it, doesn't matter what the intent was. You'd want to know whose fingerprints were on that pen.
Yes.
Okay. Ms. Howard, would you want to know about fingerprints and who was holding this pen?
I guess so.
Okay.
I mean, not, yeah, probably.
So if I present you with two witnesses and they said, yes, absolutely, I saw Lorena, she was in the courtroom and she had this pen.
The witnesses said they saw.
Yes,
Would I want to know whose fingerprints were on the pen?
correct.
Yes,
Okay.
because I'm not sure I would trust the witnesses.
You're not sure what?
I'm not sure, I mean, how would I know to trust the witness?
Okay, so that's based on your judgment, your credibility. So you're going to weigh their testimony against all the other evidence, correct?
Right.
And if there's no conflicting evidence, and both of them say, yeah, absolutely, she was in the courtroom and she had that pen, would you still want to know whose fingerprints were on that pen?
Yes.
Probably.
I mean, a pen, if it was a gun, there's two different things. I mean, you talk about a pen. But if it was something more, yeah, I would probably want to know whose fingerprints.
And does this, and even though the state's not required to show whose fingerprints were on the pen?
Even though the state is not required
Correct.
to prove.
To prove whose fingerprints were on the pen.
Yeah, no, and if the state wasn't required, then why would I want to know fingerprints?
Okay. Mr. Lester, what about you?
So it's just the idea that there's a pen in the courtroom, nobody is guilty of bringing it in, just that there is a pen in the courtroom.
You're guilty of breaking Florida law if you have a pen in a courtroom. And the state prevents you with testimony, with witness testimony, with evidence that I was in fact in the courtroom and that I had this pen. Would you say the state has met its burden?
I would say so.
Mr. Hayes?
Yes.
Mr. Smith?
Yes.
Is there anybody else here that would require the state to prove more?
What about if the person did not know before they pick up the pen?
They didn't know they picked up a pen?
Before they took, like, I heard everybody doing something. So what about if the person didn't know what the law is?
Okay. And that's a fair question. Everybody here has heard ignorance of the law is no excuse. So we're all we all know the law. That is what we are all we're all expected to know what the law is. Does everybody know that? Does everybody understand that? Even though we may not agree, and of course we may not know every single law. You're expected to know what the law is. So if in that example, I would add that the person holding the pen had to know that they grabbed that pen with the intent to break the law, I'd be adding a third element, correct? Of intent. And then the state would have to prove that third element, that that person knew by picking up that pen, she was then violating the law. And in my hypo, I only have two elements. So you had to have the pen and you're in the courtroom. Does everybody understand that? The distinction that bringing in intent would require the state to prove an additional element. And in this case, it's not required. The same thing as if somebody would require or wanted to know what the color of the pen is. The two elements don't require the state to prove the color of the pen, correct? So it doesn't matter if it was a red pen or if I was holding a blue pen or a purple pen. As long as testimony and evidence is presented that it was a pen. Do you agree with that, Ms. Starkweather? Now let's talk about the crime the defendant is charged with, which is of resisting or obstructing opposing a law enforcement officer.
I didn't hear.
So the crime that the defendant is charged with is resisting, obstructing, or opposing a law enforcement officer without violence. Now, the judge is going to instruct you later that there is no legal definition for resisting, opposing, or obstruction. What you have to do as jurors, if you're selected for this case, is to use your own personal experiences and your common sense of what those words mean. Now, Miss Rothring, you've got children, young kids, correct?
Yes.
Boys or girls?
Boys.
How many do you have?
2.
And do they always listen to you?
No.
Now, would you say that maybe you were trying to get them dressed, you were on your way out to the grocery store, and you're trying to get them dressed, and you're trying to put on their shoes, and they start kicking their feet, swaddling at your hand.
Mm-hmm.
Would you say they're resisting your ability to put their shoes on?
Yes.
Miss Clydesdale, you've also got young kids.
Yes.
Would you agree with Miss Rothringer?
Yes.
Ms. Howard, would you agree with that? Now, obstruction. Can anybody think about a time your child obstructed your ability to perform a task? Anyone? Okay. Well, let's go back to Ms. Rothringer, because you're also a teacher.
Yes.
Right? And in these very unusual times we're living, we're in the middle of a pandemic, and we're doing a lot of virtual learning. So, would you say that if a child was at home doing virtual school, and it was time for math, and they don't like math, they hate math, which I don't blame them, it's my worst subject. And mom comes out and says, it's time for math. And mom is trying to find the math book, and the math book can't be found anywhere. And she spends 30 minutes searching for this book, because it's math time, we need to do our math course. She takes a break, goes make dinner, comes back, and says, okay, let's look again. She even goes into the garage, she goes into her car, she even looks in the trash bin, because she remembers she threw trash out that morning. And finally, after another 45 minutes of searching, she finds the math book in the guest bedroom, underneath several pillows. And when mom asks her daughter, how'd they get here? Oh, well, I put them there. I didn't want to do math. Would you say that the child hiding the books obstructed her mother's ability to perform, to do the math lesson with her on time?
Yes.
Miss Clydesdale, would you also agree?
I would actually say that she obstructed her own ability to
Okay, you would say her own ability to. And now it's maybe later in the night, and now she's got to do math. Miss Stockinger, would you agree?
Yes.
What about you, Mr. Hayes?
Yes.
Mr. Smith?
Yes.
Mr. Antinasio, would you agree?
Yes.
By not providing the course materials, the child obstructed mom's ability to perform that task, correct? Does anybody disagree? Now, this is a true story. My sister called me about a few weeks ago and told me this. So she's going mad crazy trying to find that math book. Miss Shikala?
Close.
Close?
Yeah.
How do you say it?
Shikala.
Shikala. Have you ever been stopped for speeding?
Yes.
And how was your interaction with law enforcement?
Fine.
Do you agree that you were speeding?
Yes.
And when you had your interaction with law enforcement, did you comply with the officer's requests?
Yes.
And do you believe that you had a duty to comply with those requests?
Yes.
Even though you may think it might have been for a minor infraction such as speeding?
No, I agree with the request.
Okay. And why did you comply?
Because that's what was required. That's what I was told to do.
Okay. And would you agree that the officer was doing his job?
Yes.
And is there anybody here that disagrees with Ms. Shikala? Mr. Hayes, do you agree that if you come into an interaction with an officer that he's, maybe pulled you over for running a red light?
Yes.
Do you agree that he's doing his job?
Yes.
And do you agree that you have a duty to comply
Yes.
with the officer?
Yes.
Mr. Lesser, what about you?
I agree.
Mr. Smith?
Yes, I agree.
Mr. Joseph?
I agree.
Is there anybody here that disagrees with that? Now, can anybody else give me another example of possibly a legal duty that an officer has as part of his job? Ms. Starkweather, can you think of any other legal duty an officer has?
If two people are interacting physically, it's like a domestic violence thing, that officer would need to come in and stop that.
Okay. So maybe
if people are not able to do that at that point.
themselves. Okay, so responding to maybe some sort of disturbance. Ms. Howard, can you think of anything else?
If a store was being robbed, or someone was stealing something from a store, a police officer might be called in
Okay.
to handle the situation.
Okay. And you think they would question witnesses?
Yeah.
Make
people in this.
and make an arrest if they had to? What about you, Mr. Parr?
Enforce laws.
Enforce law?
Ordinances, and keep the peace.
Okay. Keep the peace and enforce traffic laws, county ordinances.
Yes.
And I see that you're a retired law enforcement officer?
Yes.
Okay. And how long were you an officer for?
28 years.
Okay. And where were you an officer at?
In New Jersey.
And do you think you heard what the defendant is charged in this case with? Do you think your ability to sit as a fair and impartial juror here today would be affected by your prior career?
Absolutely. I have arrested people for similar charges and decided on various ones.
Okay. And Ms. Clydesdale, do you, I see that you have got law enforcement members or friends in your family?
Not in my family, just friends.
Just
Yeah.
friends?
Yeah.
Okay. And are they here local?
Yes,
And do they talk to you about their job?
periodically.
Okay. And do you think the fact that you've got friends and you speak about the job, that would affect your ability to sit here as a fair and impartial juror if you're selected today?
No.
You'd be able to put that aside?
Yes.
Mr. Hayes, what about you? I also see you marked on your questionnaire, you've got friends or family members that are law enforcement?
My father is a retired police officer,
And how long was he an officer for?
27 years.
And was that here in Florida?
No, Indiana.
And did your dad talk to you about his job?
Yes.
And do you think you can put that aside for today's trial? Or do you think that would affect your ability to sit as a fair and impartial juror?
My dad taught me to respect law enforcement, so it would affect it, yes.
You would affect it? And when you say it would affect it, how so?
Like I said, my dad taught me that you always respected a police officer. If he asked you to do something, you did it.
Okay.
If he asked you to step aside, you step aside. If he asked you to stick your hands out so he could put cuffs on you, you stick your hands out so he could put cuffs on you.
Okay. And would you be able to listen to all the testimony and the facts presented here today, and weigh that, those facts and testimony, without the experiences that your dad instilled in you?
I definitely look at the facts, yes.
And would you weigh the testimony and the credibility of a law enforcement officer more than a regular civilian?
Absolutely.
Okay. So would you start off like that, or would you kind of weigh it depending on what the state presents today?
I'd start off like that.
Okay. Yes.
I didn't check yes because my brother's retired, but he was a police officer.
Your brother was a police officer? Okay.
I thought that he was retired, it didn't count.
And so same questions to you, Ms. Stockinger. With the fact that your brother was a police officer, would you give more credibility to the law enforcement officer because of that relationship?
No.
No. You would be able to put aside that relationship and just listen to the facts and evidence presented here today? And same question to you, Ms. Starkweather, since your brother was a law enforcement officer.
Retired, that's why I did not check that.
Okay.
But no, I did not have a problem.
Okay. You'd be able to put those experiences aside and just listen to what's presented here today at trial? Is there anybody else here who, like Mr. Hayes, may give law enforcement more credibility right off the bat because of a relationship or, friend that they have? Mr. August? You too, you've got family members or friends? Friends. Mr. Rome, you'd be able, what about you?
I don't have any family, all the time.
So you would just weigh the testimony from a civilian witness and a law enforcement officer equally? They would start off at the same playing field? There's a little hesitation on your part.
I say yes.
Yes? You'd be, okay. Ms. Howard, what about you?
I want to say yes,
Okay, but?
but I have to believe I think police officer.
It's okay. We're here to be honest. That's okay. There's nothing wrong with that.
I would hope that I'd be able to listen to it and make, an educated decision.
Okay. So you'd be willing to sit and listen to all the evidence and testimony presented first?
Yes.
And then based on that testimony and evidence, you would weigh everyone's credibility that testified? And then would you be able to come to,
Be able to come to some kind of decision.
okay. Mr. Lesser, what about you?
I think we've always taught to respect police officers. And I would think that my first opinion would be that the police officer is correct.
Okay. Now, when you said you were always taught to respect police officers, does that mean they're always right?
Sorry?
Does that mean they're always right?
Well, I would have to look at it open-mindedly, but if the police officer tells you to do something, you should obey it. I mean,
So you would be,
would I be prejudiced toward a police officer?
I'm sorry?
Would I be prejudiced toward a police officer's opinion, or is that what you're asking?
Would you give them more credibility just
Yeah, I
because they're a
think so.
police officer?
I think I would.
Okay. But then you also said you're willing to listen to everything?
I would listen to everything open-mindedly, yeah.
Okay. And if you thought the law enforcement officer was not right, or you disagreed with them, would that mean you still automatically give him more credibility?
I have a tendency to lean toward the police officer.
Anybody else agrees with Mr. Lesser?
But that's from an authority, being raised to respect authority. Yes.
Okay. And Ms. Blaisdell, you said being raised to respect authority, but again, the same question I posed to Mr. Lesser, does that mean you're always going to agree with a police officer?
No, not necessarily.
Okay. Mr. Hayes, you too. Does that mean you're always going to agree with the police officer? You will. Ms. Starkweather, will you always agree with the police officer?
I would want to look at both sides, but I agree with Mrs. Blaisdell that we are taught to respect authority, governing authority.
Okay, and that's a good lesson most people are probably taught. But like I said, that doesn't necessarily mean you always agree with an officer, correct? Is that a yes? Yes. Is there anybody here who thinks that the crime of resisting, opposing, or obstructing a police officer should not be a crime? Let me say it again. Anybody here that does not believe that resisting, opposing, or obstructing an officer without violence should not be a crime? Because it's just part of the job. They have to deal with difficult people. Or, people that are having bad days. Nobody agrees with that statement? Mr. Joseph?
I think there definitely should be consequences.
When you say you think there should be consequences for what?
I think there should be consequences if you're found to have, I don't know, it's tough in my mind. I don't know necessarily that it should be a crime. I think that it is a part of the job. If you are being violent, I definitely think there should be. If you're being non-violent, if you're expressing your opinion, I don't know. It's tough. I think it's a tough question, to be honest.
So you think?
I don't know what I fall on that.
Okay, so you think if you're resisting, opposing, or obstructing an officer with violence, you definitely think that should be a crime?
You said I definitely think that should be a crime?
Do you think that?
I don't definitely think that should be a crime.
If it's with violence?
Oh, I'm sorry, with violence.
Yes.
My apologies. Yes.
If they struck or hit a police officer,
Yes.
do you think that should be a crime?
Yeah, I mean, if you did that to anyone, that would be wrong to do.
Now, in this case, it is resisting, obstructing, or opposing an officer without violence. So, kind of going back to the scenarios and the hypos we gave with kids, if they don't comply with orders, if they refuse, to provide something, do you think that should be a crime? Or do you think it's just part of their job to deal with difficult people?
Again, I think there should be consequences, but to say it's a crime, in that scenario where you're with your kid, are you going to say that that's a crime because they obstructed you from being able to help them with their homework?
Well, you're right, that's not a crime, it's a hypo. But
it is a hypo.
If we put it in the context of a law enforcement officer who is performing a legal duty, do you think it should be a crime? You're a little unsure.
I am. I'm weighing in my mind. There seems to be a logical answer, but also
It
I think that
depends.
there's just tons of facts that could go into it, and it depends. And it's
That's
that
the famous
it's that-
attorney
yes.
word.
It's the education, right?
Yeah.
That's what my mind automatically goes to. It depends. And it makes it a little bit more difficult though, because there's not really a definition for it, as you pointed out earlier. So.
Right. You have to use your own
Yeah.
experiences. Miss Stokinger? Stokinger, you.
That would almost mean that if a police stops you for speeding and you're obstructing it by not showing him your license and registration, that's obstruction, right? And that's a crime?
Obstruction, yep.
That's considered a crime?
Yes. Would you agree that
That's,
should be a crime?
that seems like, it shouldn't be a crime.
That it shouldn't be a crime?
John, I'm going to object to this. It's,
Yeah, we're getting,
Oh, this is,
no, not for you, more the question that was asked. I think, that's really what we're going to wrap it up.
Yes, Your Honor. Okay. Is there anybody else that thinks that resisting an officer without violence or obstructing or opposing an officer without violence should not be a crime? That it's just part of their duty or of their job?
Question.
Sure.
What does that look like?
What is that?
What does that look like?
What does what look like?
Like arrest without warrant.
Resisting or obstructing or opposing?
Objection again, Your Honor, starting to lay a foundation.
And we can't pre-try the case without you hearing the facts. I know it's difficult to get the cart before the horse, but I guess the point is, there'll be an instruction as to what resisting, what the law is, and then you guys decide, do these facts constitute a law, a violation? And if you say they don't, then they don't. It's a not guilty verdict. If you feel that it was a violation, you come back to the verdict of guilty. I'm
We're
sorry,
not
I'm
constituting a
sorry.
law, but
I'm sorry, I don't know. I didn't see it.
I still couldn't hear what you're saying.
I said I apologize.
Oh, no, don't worry about that. I'm just saying that there's certain things we can get into North Ireland, there's certain things we can't. And then there's that fine line, where you get to. We're starting to creep over that line. All right, because that's where I'm trying to prevent us from getting into that aspect.
Mr. Grayson.
Yeah, I just want to clarify. I am able to, if the judge reads into the jury instructions and says that this is a crime, I'm able to understand and respect that is a crime under Florida law. And I'm able to make that determination, an appropriate determination based off of that. I just wanted to clarify that. Whether I think it should be or not, it's a completely different subject, and I can leave that out of it.
Right. As long as you can follow the law.
Yeah, but again, like I said, it makes it a little bit more difficult because there's not a definition, but I'm sure the judge will clarify that in jury instructions.
Okay, is there anything else anybody hasn't had an opportunity to say that wanted to say something, or you think there's something I missed that I should have addressed? And finally, is there anybody here that can't, for whatever reason, can't sit in judgment of another person, that be it philosophical, moral reasons? Yeah. Is there anybody here that for any reason, such as morally or philosophical reasons or religious reasons, can't sit in judgment of somebody else?
What for somebody else?
Can't sit in judgment of somebody else? And is there anybody here that's got any sort of anti-government biases, whether it be for the state or, the justice system, the defense, law enforcement, other than we've already spoken about? Okay. All right. Thank you so much for your time. I appreciate it. Sure, I'm just going to play down the audio for
May it please the court, counsel. Good morning, ladies and gentlemen. Can you hear me?
Yes.
All right. When we first started, you were asked if anybody is excited. Nobody raised their hand. Anybody want to raise their hand now? They're still in that. Now we are getting excited. This matter did a good job. That's great. All right, my name is David Wilson. I'm here on behalf of Mr. Allen. We're certainly glad that you guys are here today because if it wasn't you, we as citizens would not be able to exercise one of the most fundamental rights that we enjoy in this country. That's a trial by a jury of your peers. So again, on behalf of all of us, thank you for being here. All right, let's just jump into it. That's the good thing about going last after the judge and Ms. Matarina is I'm going to be a lot shorter because she's already covered most of the stuff. Okay. So I believe it was Miss Shikaluk or Miss Rothring stated they were stopped for speeding? I think it was Miss Shikaluk, right? Yeah. Just real quick, ma'am, when you were pulled over for speeding that time you were talking with Miss Matarino, how did that officer appear?
I'm not sure what you mean.
What was he wearing?
A police uniform.
Okay, so he had like a badge that was visible.
Yeah.
Okay, kind of like a nice shiny, type uniform. Marked police car.
Yeah.
Okay. Anybody here ever been stopped by a police officer that was not wearing a uniform, such as?
Objection, Your Honor.
Okay. Now, never mind that. Who here, when they walked in here today and saw Mr. Allen, thought to themselves, oh no, what did he do? No? Nobody? Okay. Trying to skip over everything that she's already covered so that we don't duplicate our efforts. All right. Is everyone here familiar with the Bill of Rights? Yes?
Yes.
Everyone? Okay. I'm sure, Mr. Joseph, you are? Okay. You know what the first 10 amendments are?
Off the top of my head, I do not.
Oh, that's the Bill of Rights. Okay.
Yeah.
Since everybody said yes, how about you, Miss Rothring? Can you name your favorite amendment? Okay. What do you think about that amendment?
You can say things.
Okay. So you would agree that it's okay to ask questions?
Yeah.
Okay. Anybody disagree with that? No? And Mr. Parr, my understanding, and I didn't get to hear this, so I have to ask you again. My understanding is you're retired chief of police up in New Jersey?
Yes.
Okay, and Ms. Mandarino had asked you if that's gonna affect your ability to be a fair and impartial juror. I didn't hear the answer to that question. Would you mind?
Absolutely. I have arrested people for civil charges as this gentleman has been charged with, and others, and I have also handled civil cases, civil torts and lawsuits involving similar and also a lot more serious claims and charges against the department.
Okay. So you're saying you could be impartial, or you?
I will not be impartial.
Okay.
I've also, sir, based upon what I've already heard, I've dealt with situations that were not violent, that might be up to interpretation by some attorneys. But since I have also made similar arrests,
right,
under those circumstances, I don't want to say to comply means, but I would definitely be, would not serve the defendant well.
No. Okay. Thank you for your candor, sir, and also thank you for your service. Okay, and Ms. Mandarino did touch on this. I'll just touch on it again. And that is that everybody here would agree that the state has the burden of proof. Is that right? Okay. Does anybody here think that the defense has a responsibility to present any evidence? No? Is there anybody here that would hold it against Mr. Allen if, let's say, he didn't testify? No? All right. Who here would expect Mr. Allen to testify? Ma'am, go ahead. Ms. Starkweather? Oh, Sophie Johnson. Go ahead. You would expect Mr. Allen to testify, or what are your thoughts on that?
Well, if he's the one being accused, I think he should speak up for himself.
Okay. All right. What if I were to tell you that the Fifth Amendment guarantees the right to not testify and to self-incriminate? Would you be able to
Well, you
accept?
would have to get up and say that he's pleading the fifth.
Okay.
But you would, want him to have his chance to say something if he wanted to.
Right. So, but deep down inside, you think it'd probably be more appropriate that he does testify because he's being accused?
I would think so. I mean, why not?
And Ms. Clydesdale, you're shaking your head. Does that mean that you agree as well?
Yes.
Okay. I think I saw some other. Sir?
I agree, you ought to speak for himself.
Okay. All right. Anybody else have anything on that? All right, almost getting there, folks, and I know you're probably aching for a break here. All right, who here thinks that as we stand here right now, with all that's gone on so far in this proceeding, that Mr. Allen is innocent? No one? No, nobody does? Okay. Are you guys familiar with the concept that here in this country, a person is presumed innocent until proven guilty, correct? All right, so with that being said, if I were to ask you that again, would you agree that you ought to raise your hand and presume his innocence? Since you haven't heard anything other than what we've just been talking about. Is that a fair statement to make?
Yes.
Yeah, no hesitation from anybody? Mr. Hayes, you look like you don't want to answer that.
No, that's.
Yes, okay. All right, well, I think that's all I have for you folks. Thank you very much again for your service and for your time. We really appreciate it.
All right, ladies and gentlemen, I'm gonna let you step out in the hallway. Okay, we're gonna take a break. The attorneys will confirm with me if you can pick a jury, okay? And then as soon as we do that, we'll bring you back in.
clear, Your Honor.
Okay, all right. You look at your notes.
Remember the Western tobacco use for that self-interacting.
Sure.
I'd like to do that also.
Yeah, I need to.
Yeah, we all right?
Is there a way to pause the YouTube video?
Sure, I can turn off both the video and the, okay, for, that one record is the president. Matrino, any challenges for cause?
Yes, Your Honor, state witnesses right there, number one, Noel Cruz. He did say he didn't understand, or speak the English language very well.
No objection.
I'm sorry?
No objection.
All right, Mr. Cruz will be stricken then. Hang on just a second, let me just, keep track of what I have. So Stockinger will take, Stokinger will take that seat.
So what was that with the Stokinger?
Stokinger will be the next one down. She's not sure herself.
Oh,
I'm gonna go ahead and move them down into the, where they'll come.
oh, I see what you're doing, you're moving.
Okay? Anyone else?
Your Honor, state witnesses right there, number four, Mr. Mark Joseph, he does have sickle cell, and he did say he's, not sure if that would affect, him today. He doesn't want to take the chance that halfway through this trial, he would get possibly ill. And he also expressed that he, very hesitant to say that it was a student officer without knowledge of the crime.
Mr. Wilson? Mr. Joseph? Any objection for the cause?
Oh, is this for cause? Yes, Your Honor, if no objection, I thought she was using for injury. First, he did rehabilitate himself in reference to the sickle cell disease, when he was asked about it. Ms. Manfredo actually asked him quite a bit about it, and I think he sufficiently was able to relate it wouldn't affect him. In addition to that, the other issue, he also self-rehabilitated himself by saying that if the judge tells me what the law is, I am going to be able to follow the law, following that discussion that they had concerning the resisting without violence charge.
I have denied the challenge of cause for Mr. Joseph Reynolds. The medical issue is issue at this point in time. And again, I do agree that he did kind of indicate that he would follow the law as instructed. Any other challenges for us? This matter?
Your Honor, this case we moved to strike number 6, Ms. Jerome. She did say that she was concerned about the individual knowing the law, but if they did not know the law ahead of time, the state was to strike that juror. And that was in regards to my kind of courtroom scenario.
I'm sorry, what were the grounds of Mr. Jerome?
Mr. Rome, when I was discussing the hypothetical with the in the courtroom, and she said, well, you know, they don't, what if they don't know the law? Not everybody knows the law.
Okay, yeah, we would object, Your Honor. I think Ms. Manfredino fully rehabilitated her when she explained to her and educated her that ignorance of the law is no defense.
She never said she wouldn't follow. So
yeah.
Deny your motion on Mr. Jerome. Any others?
Mr. Juror number 11, Mr. Marrero, he did not hear and had a very hard time hearing himself and the other jurors all along what was on the trust.
No objection.
All right, I agree with Mr. Jordan. Didn't hear that he could follow along with what's happening. Not sure if it was a hearing problem or a language issue or a combination of both.
Yeah. Other statements also to strike juror number 14, Gregory August. He did say that he would hold the state to a higher burden and impose additional elements when I was discussing the court or dependent courtroom scenario.
We would object to that, Your Honor. I mean, this is a lay person who essentially is, being, saying that the state should be held to a higher burden in terms of proving a criminal defendant's guilt. I think he just kind of conflated what that standard is with his own layperson understanding of it. In addition to that, he also, as I said, that he would tend to give credibility to the police, but that he could also be fair and listen to all the evidence.
Your Honor, also to have a note that he said he tends to have more credibility for law enforcement officers. They don't want that officer to be free to listen to all the evidence to be behind it.
Mr. August could say anything he could in order to get a jury view was my impression. I'm not sure that I want to be one of the jury at this point. I don't know if he's fair to anybody himself, so I got to grant the motion. So I'll straight Mr. August from the panel for cause.
Your Honor, the state also moved to strike juror number 15, Daniel Brundage. He also, just as I finished my question with Mr. August, I went to him and he said he did agree with Mr. August that he would hold the state to a higher burden. And he, the one that said he would want to know the fingerprints and who had this pen. Even after explaining that the state only had 2 elements to meet, he still wanted more.
Again, we would object, Your Honor. These are common because a lay person is not trained in the law. The hypothetical did at certain points get somewhat complicated and difficult to follow. So based on that, we would object.
I agree it was complicated and hard to follow, but he also did one of a lot of things that he was directly confronted with the fact that they only had the proof too. He was pretty much adamant that I think the answer to these questions, so I don't think he's going to follow them all. So I made a note with a little error when you were already there. I thought Mr. Brundage would not be a fair and partial juror, so we'll grant the state's challenge for cause. Any others?
No, Your Honor, no one say.
Mr. Wilson, challenges for cause?
Yes, Your Honor, juror number 2, David Hay, are we using an actual juror number or whatever?
Well, we have them listed as 2, so we
Yeah.
just use that number.
Okay,
Meeting chart.
David Hayes, he was actually not shy about, number one, let us know his father was a retired police officer, that he would definitely be biased. He could not be an impartial juror.
Any arguments?
No, that's Your Honor.
All right, is district cause. I'll bring down Ms. Howard to that seat. Any other cause challenges?
Philip Lesher, Your Honor, he has bad hearing. On several occasions that he indicated he wasn't able to hear what was going on. In addition to that, he stated that he would lend more credibility to the testimony of a law enforcement officer. So we would move to strike him.
Your Honor, David Jack, he did say he could hear everything. I don't think he ever even asked me to repeat anything. And also, he did say that he gave more credibility to law enforcement officer, but then further questioning for myself, he did say he would look at all the evidence openly, and then make a determination.
Well, I don't have a problem with this hearing, but 2 things. 1, Mr. Allen would have to testify, and 2, with the law enforcement officer, I think he used the word prejudice, that he would be prejudiced. So I'm going to challenge the cause of Mr. Lesher.
What number is that?
I'm sorry?
What number is that?
I have it as under yours, number 3, on this chart, which would bring down his rolling.
Probably interrupt, but it just started getting filed, at least at the top, it has the wrong judge.
That's incorrect. Okay, we go to that. Thank you.
You said that somebody on the road.
Yeah, I was, but that purpose informed me she's correctly out. Any other challenges for cause?
Yes, Your Honor, yeah, Ellen Stockinger, number 7. She stated that, number one, at least she got kind of tainted with that conversation she had, that question she asked Ms. Mandarino, that we could put an end to. In addition, she fully expects Mr. Allen to testify. She pretty much manifested that that would be required.
No objection, Your Honor.
All right, Ms. Stockinger will be stricken, and that brings down this dark one. Any further challenges for cause?
Yes, sir, I got 2 more. Amy Clydesdale, number 12. Again, with the requirement that Mr. Allen testify, she did express that she would expect him to testify since he was the accused. So that would be
Your Honor, the state would object and say that when Mr. Wilson asked regarding presumption of innocence, she did agree that he was, Mr. Allen is innocent and completely guilty.
Yeah, I didn't make a note of the Ms. Starkweather in reference to that, or, excuse me, we're talking about Ms. Clydesdale, right?
Yeah, Ms. Clydesdale.
Again, I'm going to deny your motion for call of challenges for cause for Ms. Clydesdale.
Then finally, Your Honor, I have John Parr, number 17, the retired chief of police. He vehemently, I think, in full candor, told the court that he would not be, I think, I'll quote him, I would not be good for the defendant.
It wouldn't end well. All right, so Mr. Barlow, restriction of costs. So the first 6 that I have.
Will you allow asterisks, Your Honor?
I'm sorry?
Will you allow asterisks?
Yes. I have Starkweather, Howard, Ms. Rothman, Mr. Joseph, Mr. Smith, and Ms. Jerome. Is that you have that one?
Yes.
Judge, can you repeat that for us, please? Joseph?
I have Starkweather in the first seat, Howard, 2, Rothman, 3, Joseph, 4, Mr. Smith, number 5, and Ms. Jerome, number 6. So preemptive challenges from the state.
Table to strike, juror number 4, Mark Joseph.
And I'm going to bring down Ms. Clydesdale. Further challenges from the state.
Did the state go or did not go?
You go until you're done. We run out of jurors just in case you need.
State strike juror number 6, Mr. Jerome.
That would bring down Antanasio. Do you accept that panel this time?
Yes, sir.
Mr. Wilson, it is Starkweather, Howard, Rothman, Clydesdale, Smith, and Antanasio.
Yes, we move to strike Rothwing,
Then bring down Ms. Hadley. Okay, you accept that panel?
no, hold on now. We move to strike Clydesdale.
And that brings down this, Chicago, I believe. Do you accept the panel as, at this point in time? You won't strike left.
Are we live, Judge?
Yes.
It is live. I don't know. It picks up from there, not from my microphone.
The main one is on.
Because I'm whispering, but I'm waiting right over the microphone.
All right, if we accept the panel, Your Honor.
Your Honor, the state strike juror number 8, Ms. Howard.
All right. bring in more jurors. Okay. How many jurors do we have in the waiver course? We still on track for one day?
I don't know.
I think it's gonna be closer.
I like it. But I'm not taking it off. Based on my reading of the sheet and what you guys said today, I'm not going to subject anyone in the city for 2 days for no reason.
So it's my eyesight still.
I understand, you know, but really? Precious time, I'm not sure why I'm here today. My feeling, you know. So we can do this, we can bring this panel back, I can release whoever is not on the jury panel. I'm only going to need to pick one out of whoever's left. So what I'll do is I'll send them back for lunch or out for lunch, and then hopefully we can get through the rest really quick. We only really need 2 jurors, 3 jurors. I guess I'll let you go through that. And we'll have to marry them off later after lunch. Hopefully it won't take too long. So we'll see. We'll have to come back and wait, and I'll come back and wait for them. But I will need to get this to an opportunity for lunch too.
We have 16.
16. Bring them in. Well, don't bring them in yet. Just bring in the panel that we have.
And Judge, how do you, how many strikes does everybody have for this next round?
State as usual, all the directors, you have 1 left.
So we go 16?
Not really. But I mean, that's up to you. I mean,
I
what
guess
you guys have in terms of cause
Yeah,
challenge.
the dangers are we gonna do for cause, so.
I doubt that you would run all 316 with the notice. Let's bring the original panel that we have out.
Rod?
All right, ladies and gentlemen, just to let you know, oh, you may be seated. We almost have a jury panel. If your name's called, if you'll please stay here. If your name is not called, then you are free to go. And my understanding that you can leave from here. And I want to thank you for your service here this morning. The following individuals have been tentatively selected to try this case. Mr. Douglas Smith, Cynthia Starkweather, Drew Antanasio, Susan Circulak, and Christine Haggard. If your name wasn't called, again, you're free to go, and thank you very much. The rest of you, if your name's called, you'll just remain seated. All right, ladies and gentlemen, those of you that are remaining, what I'm going to do, because we're going to have to bring in the remaining part of the panel, we'll go through the process again, and then hopefully we'll be able to pick a juror out of that group. But what I'm going to do is, rather than have you wait around here, I'm going to send you out to lunch today, right now, because I don't know how long that other process is going to be. Have you come back around 12:30. That'll be great. The bailiff will tell you where you need to meet, and I think they'll have you in courtroom 2C once you get back. But when you do come back, in the meantime, hopefully we'll be able to select that juror, and it may be some delay depending on how long it is. You may have to stay back in 2C for a little while, but I'll need to, whoever else gets selected will need to have an opportunity to get to lunch too. And then we'll get everybody together and we'll begin the trial at that time, okay? So with that, I'm going to go ahead and release you for lunch and then see you back at 12:30. Thank you. All right, I don't know where the other panel is. Yeah.
You have packets for those jurors?
Excuse me?
Apologies, Your Honor. Do you have packets for those jurors?
Not yet.
I'm assuming they'll be bringing them down with the jurors.
Thanks.
Hopefully.
You can use one outside right now, we don't have to.
Your Honor, the jury pool.
And fairly good morning, ladies and gentlemen. My name is Judge Provost. We do have a trial, criminal case for consideration this morning. We had the earlier panel. We have a few members that are selected. We still need a couple more to go. So we brought you down here. We're going to go through the process called voir dire, where you'll be questions concerning your feelings about certain issues and your ability to try a case fairly and impartially. I want to thank you for your attendance. I just want to let you know that we are trying to make sure that everyone stays safe. That's why we're doing the social distancing. The masks that you're wearing are only going to be used during the course of the voir dire process. After that's over, you can either continue wearing it if you wish, or you can put on any mask that you brought in with you when you came here today. I would ask that you maintain the social distancing as well as washing your hands and such after, if you're selected on the jury with your other jury members. They've been instructed the same thing earlier this morning. We do have, because we have limited the number of people who are in the courthouse at any one time, rather than having the members of the general public being able to appear, we are now streaming these proceedings live on a YouTube channel. The camera during the course of the trial and in this process will not be on any members of the jury, so your privacy will be maintained during that time. There's a few things I just wanted to go over with you quickly. Before we begin, I just wanted to introduce you to some of the individuals that you would see here in the courtroom. The bailiffs that you've met, again, they do assist me if there's any issues that come up or any concerns that you might have. Let them know, they'll get that to me, and we'll see if we can handle them. Some of you, if you've served on a jury before or have not done so recently or have watched TV, you might notice, well, where's the court reporter? The court reporter basically is, we are electronically recording these proceedings. You'll see the microphones, they're very sensitive. They can pick up what you have to say. However, I would say this is based on my experience earlier this morning. It would be helpful if you did still speak a little bit louder so that the attorneys can have an opportunity to hear what you say. We tend to get a little muzzled, especially with this type of face mask, as opposed to what you're wearing. But that does help. Let's see. One thing that we had discussed earlier is that just wanted to let you know the length of the trial. We're still going to try to hopefully get done today. There may be a possibility that it could go into tomorrow. Does that cause any problems or issues with anyone here? Yes, sir. That would be Mr. Is it Gustavo? Oh, Mr. Coleman, Mr. Macedo.
Yes, my wife, they have operation tomorrow for cataract.
Okay. Any objection to these released?
No objection, Your Honor.
No objection, Your
All
Honor.
right, sir, you're free to go. You may leave.
May I leave?
Yes, sir. Yeah, I'm afraid to ask the question again. No, okay. I like I say, we'll work real hard, and my anticipation, if it is even for tomorrow, will probably be for no more than a half a day to try to get that resolved, okay? So I'm assuming that no one has any child custody or with either school or other elderly care today. We should be able to break hopefully around 5. Depending on where we're at, we could kind of squeeze out a little extra time. Is that an issue for anyone here? Okay. imagine most people would rather resolve it today than have to come back tomorrow. Any disagreement with that? No? Okay. Shoot, you saw a video this morning, is that right? Everybody was here? Okay. And then part of that, then a lot of that takes care of what I would normally say. But I just wanted to stress the fact that as a trier, to the juror, as to your job as a trier of fact, you get to decide what the facts of the case are. I can't help you in any way doing that. I will instruct you as to what the law is in the state of Florida. I ask that you follow that law, even if you're from another state and you think you have an idea, because a lot of times state laws are different. And the examples that I use is that the Northeast, usually the Commonwealth states, you'll hear a crime called an assault and battery, whereas in Florida, we have a crime that's called an assault, and we have a crime that's called battery. So we have two separate crimes, they lump theirs together as one, and the definition of those crimes would naturally not be the same, because they are different. Likewise, the common thing is you see someone on TV where they say, I've been robbed, and the officer asks them what happened, and they said, I came home, and all my belongings in my house are gone. Well, technically, they've been burglarized. Now, if they were home, then there could be a robbery involved in that. But a robbery generally is a personal crime against an individual, whereas a burglary would be a property crime. And the reason I point that out is each crime has what they call certain elements that the state is required to prove to you beyond a reasonable doubt. And those elements make up what the law is, the definition of that particular law. And in order to prove someone is guilty, they have to meet each of those elements independently beyond a reasonable doubt. So if there are two elements involved in the case, they only prove one of them to you beyond a reasonable doubt, then naturally you would still have to prove the second one. And if that's not the case, then you would be entitled to come back with a verdict of not guilty. However, if both elements are met to you, to your satisfaction beyond a reasonable doubt, then as jurors, you would generally come back with a verdict of guilty. However, you decide what the facts are, like I said. So I can't tell you what the facts are. You don't get to decide what the law is. So even if you don't like the law, you still must follow it. As I tell everyone, this is not the place. This courtroom is not the place where we change laws. That's done up in Tallahassee. The legislature is in session now. Maybe a little too late to make any changes for today, but your legislatures are who you need to contact to make any changes in the law that you feel are necessary. I think I covered everything that I wanted to this morning, so I'm going to allow the state, and I'm sorry, they'll get an opportunity to introduce them, but Ms. Macarino and Mr. Rob is representing the state of Florida, Mr. Wilson, and Mr. Well, we know him for how long?
Darrow.
About 30 years. Mr. Darrow is representing Mr. Allen. With that, then Ms. Macarino, if you wish to inquire.
Yes, Your Honor, thank you. May it please the court, counsel, members of the jury. Good afternoon. So as the judge mentioned, my name is Lorena Matrino, and I represent the state of Florida and the residents of Collier County, along with co-counsel Lawrence Rabb. And we want to thank you for your time for being here today. We know jury duty is not always everyone's favorite thing to do, especially during these exceptional times that we're living in the middle of a pandemic. So we're going to try and make this quick and get you guys on your way. In order to be able to successfully do jury selection today, I'm hoping that we have an open and engaging conversation. And I ask that you guys all please put in your input and let me know your opinions that you may have, whatever it is we're discussing. Feel free to interrupt me. You can raise your hand. If you can't hear me, I'm not speaking loudly, please interrupt me. Yes, that's it. Okay, I'll try and stay near this microphone. I tend to move a lot. And also, if there's something that we're discussing and you don't feel comfortable talking in front of everyone, please just raise your hand and let me know, and we can approach the bench with the judge and we will speak privately. And finally, before we get started, if I butcher your name, I do apologize in advance. And please do correct me, because I get that all the time. I get my name butchered, my first and my last name, so that's always fun. So as the judge mentioned, and I just kind of briefly want to ask if anybody here have any sort of medical condition or illness that would prevent them from sitting here all day today if you're selected as a juror? No hands? Miss McGarity? Good afternoon. I did see on your questionnaire you said you do have arthritis?
Yes.
Okay.
Yes.
And do you think that is going to impair your ability to stay focused? And
I don't believe that. I
You don't
thought
think so?
about that, but I don't believe so.
Okay. And if you need to take a break or move or stretch, you can feel free to ask the judge for a break.
Okay.
Perfect. Anybody else have any sort of medical condition or illness? Does anybody else have anything that's so pressing or distracting that's going on either in your personal life or in, a close friend or family member that you think, just sitting here and being focused on this trial today is just not going to be possible for you? No outside distractions, we'll be able to just keep that out for today? Perfect. So I want to talk about elements of a crime, the elements that the state has to prove beyond a reasonable doubt in order to prove the crime alleged. In this case, the crime is resisting, opposing, or obstructing a law enforcement officer without violence. So before we get into those specific elements, I want to throw a little hypo at you. Miss Werder. If I tell you that it is against the law in the state of Florida to have a pen in the courtroom, what do you think are the two elements the state has to prove?
I would say that you have the pen.
Okay.
I'm assuming that the law is actually the law.
Yes.
That you have the pen, and that if you're being charged, that you're the one holding the pen.
And I'm holding the pen.
So that you have the pen in the courtroom.
In the courtroom. Okay. So would you agree that the state would have two elements? That I have to prove that I have a pen and that I was in the courtroom while I had that pen?
Yes.
Mr. Campbell, do you agree with that?
Yeah, I would pretty much agree.
And what about Mr. Amber?
Yes.
You would agree? Mr. Gustave? Well, Ms. Libreros?
Yes.
You would agree? And would we all agree that the state would have to prove those two elements beyond a reasonable doubt? Yes? See some head shaking. Now, Ms. Libreros, if I told you, if the state presented you with witness and testimony today that said, yes, I saw Lorraine and she had a pen, she was in the park, would you say that the state has met its burden?
No, because it's at the court, you're supposed to not have it, right?
Yes. So you would say, no, state, you have not met your burden. Perfect. Mr. Withrow, do you agree with Ms. Libreros?
There's no question of intent, just that they had the pen in the court.
Yes.
Yeah, good.
Yep. Ms. Dunn, do you agree? You don't understand me? Okay, so you have very limited English? You only understand it a little bit? Okay. And would you agree that maybe sitting here and listening to witnesses testify and evidence presented, you're going to have a hard time listening to them and understanding? Are you going to have a hard time listening to evidence or witnesses that come in to testify? You still don't understand me? Okay, thank you. Mr. Kreider. Do you also agree that if I present you with witness testimony or maybe video evidence that I in fact had a pen, but I was in the park, would you say the state has met its burden?
I'd say they didn't meet,
Okay. And why is that?
because they couldn't, there was no evidence that there was a pen in the courtroom.
Okay. I only showed you evidence that there was a pen in a park, correct?
That's correct.
Okay. Is there anybody that disagrees with that? Now, given the fact that the law only states that the state has to prove those two elements, is there anybody here that would make the state prove more than that? And by that I mean, is there anybody here that's going to say, well, what's the color of the pen? No. I see Mr. Kinsler. You see you shaking your head no. You don't want to know what the color of the pen is?
It's a pen.
Okay. That's all you need to know, that it's a pen. Would you agree that the color of the pen is irrelevant to prove the crime?
Depends on if the pen was used and what the color of the ink was, then it would make a difference.
Right. But does the state have to prove in those two elements that the state has to prove that I had a pen and it was in a courtroom? Is there a third element that says I have to prove the color of that pen?
No.
Okay. So you'd be able to hold the state to its burden, and in this case it's just two elements.
Correct.
Okay. Is there anybody that disagrees with Ms. Kinsler? Is there anybody here that would say, yes, maybe I want to know what the color of the pen is, purple or red, but I don't need to know? See Mr. Withrow shaking your head? No, you don't need to know the color of the pen.
No,
Because it's just those two elements.
you need to prove it was a pen. You might have to tell the color to prove that you knew it was a pen, but it's a pen and it was in the courtroom.
And it was in a courtroom. Perfect.
Pretty simple.
Now, would that also, it wouldn't matter either, see Mrs. Shields, it wouldn't matter either if the state presented you with one witness that said, yeah, she was holding that pen, she was in the courtroom, but it was a blue pen. And then you get another witness on the stand that says, yes, she was in the courtroom and she was holding that pen, but it was a purple pen. Would you still be able to find the state has met its burden? Okay. So does everybody understand that you can have conflicting testimony or evidence, and you can still find that the state has met its burden? Everybody agrees with that?
Would you have a question?
Yeah, I mean, the only issue would be if this conflicting testimony goes to whether they actually saw it, it's the credibility of the witness, right?
Yes, at that point, then you would judge the credibility of the witness. But in that case, they're both telling you, yes, she was in the courtroom and she had a pen.
Right.
So would you still be able to come back and say, yes, the state met its burden?
If I believe that they actually saw it.
Yes. Regardless of what color this pen was.
Yeah.
Perfect. Great point. Thank you. Now, today this defendant is charged, like I said, with resisting, opposing, or obstructing a law enforcement officer without violence. So the elements of that crime are as follows. The first one, the state has to prove the defendant did in fact resist, obstruct, or oppose an officer. And that's an or. We don't have to prove all three. The second element is that the officer was engaged in a lawful legal duty. The third, that the officer at the time was an authorized law enforcement officer. And four, that the defendant knew that the officer was in fact a law enforcement officer. So those are the four elements that the state has to prove today. Now, in regards to the first element of resisting, opposing, or obstructing, again, we only have to prove one of the three. And later on, the judge will tell you that there is no legal definition for those terms. You, as jurors, if you're selected to be on this jury, have to use your own personal experiences and your own common sense to determine what those terms mean. Now, who here has children? Okay. And Miss Werder, your kids are young, teenagers almost? You have
12, one.
Mm-hmm. She's almost, he or she? He's almost a teenager?
Mm-hmm. Yes.
Let's talk about opposing. Have you ever asked your son to clean his room and he
Daily.
said no?
Yes.
Yeah. Would you say that he opposed your order?
Yes, Your Honor, this line of questioning is actually toward the facts of the case.
You're just going to have to rely on what your common meaning is or a dictionary meaning of those words.
So for and you did say that he would refuse to clean your room. Okay. Now, can anybody here tell me what they think a legal duty of an officer is? Anybody just name a few duties that they think a law enforcement officer do as part of their job? Mr. Campbell?
To enforce the law, protect citizens.
Okay. Mr. Rambert?
Yeah, ensuring the safety of citizens.
Ensure the safety of citizens. Mr. Gustav?
Enforce the law, protect the community.
Protect the community, enforce the law. Ms. Libreros?
Same thing, protecting and enforcing the law without responsibility.
And what type of laws do you think they enforce?
Given by the countries. Actually, we're supposed to be taking care of the officers. So if I'm ignorant of the law, it doesn't make me innocent, because I needed to know, or at least find out what really the common sense was wrong with that. And I bet he knows it for sure. And if he transposes or something, I guess I'm gonna find it here. But I guess that's what he's supposed to do.
So you agree that, like you stated, you can't, being ignorant of the law is not an excuse?
Exactly.
Is anybody disagrees with Ms. Libreros? Ms.
I couldn't hear what she said.
She was saying that just, you can't be ignorant of the law, that's not an excuse, and the officer would know what that law is, and they're enforcing those laws based upon the knowledge of what those laws are that they know. Ms. Siegel. Is there another a legal duty of a law enforcement officer that you can think of?
Serve and protect.
Okay. And when you say to serve, what do you mean by that?
To be a helper.
What's that?
As Mr. Rogers said, to be a helper.
To be a helper? And would you agree that that may come in different forms as far as it relates to law enforcement officer?
Absolutely.
And that may be either maybe pulling over to help somebody with a flat tire.
Yes.
Would everybody here agree that pulling over someone for violating a traffic violation is also part of their legal duty? Maybe they ran a red light. And I'm sure here a lot of people have, some people have been pulled over for speeding before. We got some people willing to admit that? Yeah, okay, great. And Ms. McGarity, in that circumstance, how was your interaction with law enforcement?
Oh, it was just fine. I was speeding.
Okay.
So I think it,
And everything worked out?
yeah, everything worked out fine.
Okay. And would you say that you have a duty to comply with the law enforcement officer's requests?
Yes.
And do you believe that regardless of what type of infraction you may have committed?
Yes.
Your Honor, I'm gonna object again. Real close.
Yeah, sustain, try to, leave it there.
Yes, Your Honor. And is there anybody here who thinks that the charge resisting, opposing, or obstructing a law enforcement officer should not be a crime? No one? Is there anybody here that thinks that that is of the opinion that maybe just dealing with difficult or dismissive individuals is part of their duty, and they shouldn't be able to charge such a crime as resisting, opposing, or obstructing an officer without violence? No one? Okay.
Your Honor, continue going down this road of asking questions.
Back let's not retry the case, okay?
Yes, Your Honor. Now, is there anybody here who would have a difficult time following the jury instructions or the law that the judge would instruct you to follow? Even if you disagree with the law, everybody was willing to follow those instructions? Even if you think it's a silly law? Now, is there anybody here who's got law enforcement members or close friends or relatives in their family? I think I saw it. Now, Mrs. Porter, would you give more weight to the testimony of a law enforcement officer versus a civilian?
Not necessarily.
Would you agree that you would start them both off at the same playing field, and depending what they said, you would kind of move them up or down?
It would just depend on their testimony and what evidence they're giving.
Okay. And what about you, Mr. Campbell?
I would agree with that, and I'd also probably want like a third party if there's someone to witness there as well.
Okay, so when you say you'd want a third party, aside from law enforcement, you're saying?
Yeah.
Okay. And why is that?
Just so I can get kind of a unbiased, maybe sort of a different perspective on it.
Okay, I mean, you said an unbiased means, what do you mean by that?
Just like, so if there was another police officer, I probably, although I would use them also, just also having, just whoever was there, just to get a clear picture of the
So would you want,
encounter.
so what, are you saying that you would feel more better if you had maybe civilian witnesses and law enforcement officer?
Yeah.
Rather than just law enforcement officer testifying?
Yeah, I would agree. I want as many people that like saw the encounter as possible. Yeah.
Okay. Would you have a problem if there's only law enforcement officer?
No.
that testified at trial? Would you be able to be fair and impartial? What about you, Mr. Rambert? Would you give more credibility to a law enforcement officer's testimony versus a civilian?
No.
Just because they're a law enforcement officer? Okay. So you would be able to sit and listen to all the testimonies presented and listen to the evidence and judge them based on that. What about you, Mr. Gustav?
Can you repeat that for me?
Are you going to automatically give more credibility to a law enforcement officer just because you're a law enforcement officer and he wears a badge versus a civilian?
No.
Okay. Would you start him off at the same playing field?
Yeah, I would just need to hear the full story between both sides.
Okay, so you'd be willing to sit and hear all the evidence and testimony and then make a determination? What about you, Ms. Libreros?
I would give people this idea.
Okay. Mr. Withrow, what about you? Doesn't matter if they wear a badge, you would start them off at the same playing field?
Oh, yeah, I want to hear both sides and decide who's telling the truth.
Okay. Mr. Kreider?
Yes.
What about you? Feel the same way?
I listen to both people. I wouldn't necessarily give
More weight to law
more
enforcement
weight to
officer?
law enforcement officer, because you have to listen to the story.
Mrs. Shields, do you agree with that? Is there anybody that disagrees with that statement? Is there anybody here who's had a bad experience with law enforcement before? Or has a family member who's had a very bad experience with law enforcement officer and and Ms. Shields, on your questionnaire, you did say you've got, you marked, I believe it was fair for hearing. Are you having trouble hearing me or you've been able to hear everything? Okay, perfect. And Mr. Wilson, same thing, same question to you. You've been able to hear everything that's been said?
Yes.
Now, is there, I'm sure a lot of people here have heard the term reasonable doubt before. We've all heard that a little bit. And later on, if you are selected for this jury, you will be given an instruction by the judge that defines what reasonable doubt is. And part of that definition is that a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. So with that being said, I'm going to throw a little hypo at you. Let's see. Mr. Rambert, you've got kids as well. You've got 3 kids. So let's say that you're at home and you just baked some fresh cookies with your kids. And you pull out the pan out of this oven just as your doorbell rings. And so you tell your children, don't touch those cookies. I'm going to go answer that doorbell. And when you come back, you find your youngest next to the kitchen island, and they've got their hands behind their back. They've got crumbs on their shirt. They've got a little bit of chocolate on the corner of their mouth, and they've got their cheeks bulging out. What happened?
Very likely they.
Yes, and there's a cookie missing. I forgot that part. There is a cookie missing. That's correct. Mr. Campbell, would you agree with that?
Yeah.
Ms. Libreros, what about you?
Yes.
Mr. Withrow?
I agree with that.
Okay. What about you, Ms. Shields? What about you, Ms. Siegel? Do you agree with that? So you're shaking your head, yes.
Yes.
Now, Ms. Barham? Now, what if I told you that as soon as Mr. Ramberg walked out of the kitchen to answer that doorbell, the next door neighbor, an 8-year-old Dennis the Menace type of kid, came in through the back door of Mr. Ramberg's house, grabbed that cookie and ate it, and turned around to Mr. Ramberg's youngest child and said, you need to stand there with your hands behind your back, put some crumbs on his shirt, put a little bit of chocolate on his corner mouth, and said, stand there with your cheeks bulging out, and don't tell your father that I ate that cookie, or I'm gonna come back later tonight and break your favorite toy. Is that possible?
I think it could be possible.
But is it reasonable?
It almost sounds like something that you'd see on a TV show.
Okay. So would you agree that it's not reasonable? It's possible, but it's not reasonable.
It's possible, but I don't see it as being reasonable.
Okay. And Ms. Shields, you're also shaking your head yes. Would you agree? Yep. What about you, Ms. McGarry? Would you agree?
Yeah, I agree. That it's possible, but not reasonable. That would be something you could make up in your mind to explain it away.
Okay.
I would think.
And what about you, Ms. Werder?
It would depend, is there a neighbor next door? I mean, I would need more facts, more information, but if there's not a neighbor next door, and yeah, then probably not reasonable, but if there is evidence that shows that's a possibility or a probability, I would just need more information.
That it's reasonable. So if there's evidence that shows that maybe it's possible, but not reasonable, would you then determine?
Sure. I mean, it seems like I need more information.
Now, does everybody understand that you can have some doubt in this case, but you have to find the defendant not guilty if that doubt is not reasonable. Everybody understand that?
Lost me a little bit there.
Let me rephrase that.
Your Honor, I think to object to that last question, this is the state, the standard.
I have instruction. I think that if you have a reasonable doubt, then you must find the defendant not guilty.
So, does everybody understand that the burden that the state has is to prove all the elements beyond a reasonable doubt? And that doesn't mean all doubt. Everybody okay with that? Now, is there anybody here that, for any reason, whether it be religious or morally or ethical or philosophical, can't sit here today in judgment of someone else? Everyone's okay with that? And there's nobody here that has any sort of anti-government feelings or biases against whether it be the court, justice system, state, the defense, law enforcement. Nobody? And Mr. Critter?
Yeah, I entered in.
I see that your spouse is an attorney?
Yes.
Okay, and what kind of law does she practice?
Well, she was a probate magistrate in Ohio.
Okay. And
we watch a lot of Dateline.
A lot of Dateline? Kind of my favorite, too. And you said she did probate, was that here in Florida?
No, down here she got it. She just practiced, she's a trust advisor.
Okay. And the fact that she's an attorney and those experiences, that you're able to put that aside if you're selected?
I'm sorry? I like lawyers.
Good to know.
On that topic, I am an attorney.
I also have a law degree.
You have a law degree?
I don't practice.
And you are an attorney?
I worked for the federal court system for 2 years. If that matters.
Is that on your, did I miss that on your questionnaire, Ms. Withrow, Mr. Withrow?
Question that asked it.
Yeah, there was no question that asked that.
That if you're an attorney?
Mm-hmm.
Well,
Says your current or occupation, but yes, it is.
I'm inactive right now, but I practiced law for a very long time.
Okay, how long did you practice law for?
Pardon?
How long did you practice law for?
I worked for the federal court system for 2 years. I worked for a big law firm for 7.
Okay.
And then I was general counsel of a public company for 3 years.
Okay. And same question that I posed to Mr. Critter, does that fact that you've got a law degree or your practice of law, does that at all affect your ability to sit here today as a fair and impartial juror?
I understand all your questions.
Okay. And you'll be able to put all your experiences aside and just focus on the evidence and testimony presented today?
Absolutely.
And Ms. Sweater, you said you also have a law degree?
Mm-hmm.
Okay. And what type of law did you practice law?
I worked in corporate intellectual property, and now I teach business law.
Business law. Okay. And same questions as I posed to Mr. Withrow, is the fact that you've got a law degree and your experience as an attorney, is that going to affect your ability to sit here today? Anybody else? Now, is there anything that anybody can think of that I didn't ask that maybe you were wondering, or hoping I would have asked, or maybe there's something you want to tell me that I haven't asked? Okay. All right. Thank you so much for your time. I appreciate it.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. My name is David Wilson. I'm here on behalf of Mr. Nicholas Allen. You guys got here at, what, 8:30, 8 o'clock in the morning? Something like that? All right. Well, Ms. Matarino was kind enough to cover most of the stuff, so I'm just going to have just a couple of brief things to go over, and we'll be done. We won't prolong this any longer than necessary. All right. How many of you here would agree with the statement that Mr. Allen is to be presumed innocent until proven guilty? Everybody? Yeah. You're agreeing also? Okay. And Mr. Gustavo, you didn't raise your hand. You don't agree with that statement?
Yes.
You do agree with it? Okay. That's great. So that means, so for example, if you ever go down the road and you see somebody that's stopped by, say, a state trooper or something like that, what is like the very first thing that comes to mind? Anybody want to take a shot at it? Ma'am? Go.
Speeding.
Speeding, okay, all right. How about you, sir? What comes to your mind when you see somebody stop?
I would have wondered what they did.
Okay. Does anybody always jump to a conclusion that they, as she said, they were speeding? Are there other possible reasons why they've been stopped? Yeah, okay. All right, everybody here is familiar with the Bill of Rights and the Constitution, correct? All right. Ms. Werder, since you do have a lot of, what's your favorite amendment?
What's my favorite amendment?
Yeah.
I don't have a particular favorite, but I'll go with one.
You like one pretty good?
Sure.
Freedom of speech?
Absolutely.
Yeah, it's a pretty important right that we have,
I would
right?
start with one since they put it first, yeah.
Okay, all right. How about you, Mr. Ramberg? Do you have a favorite amendment? Or no preference?
No preference, I guess.
No preference. Are you familiar with the Fifth Amendment? No? Is everybody familiar with the Fifth Amendment?
Yes.
Yeah? Well, for those of you that aren't, it's the right against self-incrimination, okay? And that means that in such a case like this, Mr. Allen's not required to testify. How many of you here think that because he's being accused by the state of Florida of committing a crime that he should testify? No? Nobody thinks that he should? All right, so there's nobody here that would hold it against him if he didn't testify? Okay. I got no takers on the Fourth Amendment. That's the right to privacy.
That's a good one too. See if anyone wants to.
All right. And Ms. Manlio talked about the standard of proof a little bit that, beyond a reasonable doubt. Does everybody agree? That's a pretty high standard, correct? Would you guys agree that it's the highest standard? There's a lot of work has to go into to really meet that, right? All right, ladies and gentlemen, it's been a long day for you all. I thank you very much for being here. It's only by you doing this civic duty that we all get to enjoy one of our most fundamental rights, and that's a right to a trial by jury of our peers whenever it is that we may be accused of a wrongdoing by the government. So again, thank you very much and have a good day.
All right, ladies and gentlemen, we move on. Yes, sir. Yes. I just want to ask one thing that we did not do, is just to make sure that anybody know either Deputy Jason Booth, Fire County Sheriff's Office? Anybody know Christy McLaughlin, also works for Fire County Sheriff's Office? Okay, thank you. With that then, we're going to have you step outside the hallway. The attorneys will go over their notes and we'll see if we can pick out a juror. Okay? Thank you. We'll be back as soon as we can. Yeah. One. did get a note that George and 2C wanted to know if they could go outside and wait. And then come back at a later time, which is what I was going to do. We should be here done fairly soon. I'm only gonna get the guy over there, whoever gets selected, probably about 45 minutes for lunch, maybe not. Maybe I should be able to find something that quick. Since we're also past the lunch hour. And then you guys can punch too, so in any event, once we do that, I'm gonna go down there now, well, I don't know.
I think this is gonna be really quick, Judge.
Okay, all right.
You get one additional preempt for the alternate?
Yes.
Okay, so,
yeah.
You guys wanna?
So I think we'll be pretty good if we tell them to come back, well, let's just say 2 o'clock. Sounds good? Okay, by the time we do that. So you guys look at your notes, and I'm gonna go talk to George and 2C just to let them know.
Thank you.
You ready?
We're ready, Ron.
Challenges for cause to state.
Your Honor, the state would try to Remove the strike juror number 19, Ms. Wetter. She states that she believed the hypo that I gave her with the neighbor coming over to the house, she believed it was so possible that that could happen. Most of the jurors agreed that, yeah, possible, but not reasonable. She said that she still believed it was possible and reasonable.
If I could find out, that's not the reason to start the cause of that, which she didn't find us in time.
Yeah. She disagreed with the type of business with law. I would deny it. Any others besides mental health we need to speak to in reference to Ms. Dan, number 26?
Yeah, Your Honor, strike her for cause as well.
No objection to that, Your Honor.
Language issues.
Was that number 26?
26, yeah. Any other challenges for cause?
No.
Defense, cause challenges?
No, Your Honor.
All right. Ms. Warner is number 1. Do you accept her?
Accept.
All right, and then everybody, I guess we'll get one. We look at, like, we have Mr. Ramberg. Any objections to Mr. Ramberg as a alternate?
Would it be Mr. Campbell?
I'm sorry. Oh, yeah, I'm sorry, Mr. Campbell. I had notes there, but I didn't cross it. No, Campbell. Campbell would be the alternate. Any objection to state?
No.
Thanks.
Accept, Your Honor.
Okay. So then the list.
We needed 2 for the record. No, I mean, if we brought in a panel interview, we only needed 2. So for the first 2.
Yes, sorry.
It's kind of a joke. It would have been enough.
All right, so my notes indicate we have Mr. Smith, Mr. Starkweather, Mr. Antonaccio, Mr. Shukovic, Ms. Hadley, Ms. Warner, and Mr. Campbell.
Correct, Your Honor.
All right, if we can bring that panel back in. And I did tell the other jurors to come back at 1:45. So that's going to work out pretty good. Yep.
Looks much better, too.
Pressure on it.
Excuse me, ladies, you may be seated. Ladies and gentlemen, we have selected the rest that we needed for the jury. So if your name is called, if you'll just remain seated, the rest of you are free to go for today. Thank you very much for your attendance and your patience with us while we were waiting. The following individuals, if you would remain here, Ms. Werder and Mr. Campbell. And the rest of you are free to go. All right, Ms. Werder, Mr. Campbell, what we're going to do at this time is we'll take a break. The other jury panel is going out and they're already going to lunch, but because of the distance, I'm going to give you an opportunity to do the same thing. So I'm going to have you come back at 1:45, and if we'll follow the directions of the bailiff, then they'll let you know where you need to be at that time, okay?
Okay.
All right, thank you.
Thank you.
All right, and we'll be in recess until 1:45.
Thank you.
Thank you, Your Honor.
Back in here.
All right, so Jerry, please.
Your Honor, Missouri. All right, you may be seated. All right, ladies and gentlemen, if you would, please rise for me and raise your right hand.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and the evidence?
Yes. I do have just a couple of instructions I'm required to give you before we start. It will explain, part of the trial process and a few other things. So, again, as indicated, you have been selected and sworn as the jury to try the case of the state of Florida versus Mr. Allen. This is a criminal case. Mr. Allen is charged with resisting an officer without violence. The definition of that crime will be explained to you later. The state's charging document, which is an information, is not evidence, is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you. It is your responsibility to determine if the state has proven its accusations beyond a reasonable doubt against the defendant in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it would be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement will give the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their closing arguments. And following the closing arguments by the attorneys, I will instruct you on the law applicable to this case. After the final instructions are given, you will be then entitled to consider your verdict. You should not form any definite or fixed opinions on the merits of the case until you have heard all the evidence, the argument of the attorneys, and the instructions on the law by me. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I'll instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules, please notify the court personnel of those violations. During the course of the trial, we'll take recesses, and you'll be permitted to separate and go about your personal affairs. Actually, we'll be together in the jury room. During these recesses, you must not discuss the case with anyone or permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you are on the jury for trying the case and ask that person to stop. If they persist, please leave that person at once and immediately report the matter to the bailiff, who will then advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then you may not use your device or cell phone to find out any information about the case or to communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phone, computer, or electronic devices. If someone needs to contact you in an emergency, I can provide you with a contact number so that you can let them know how you can be reached. This case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in a courthouse, at home, or anywhere else. You must not visit the places mentioned in the trial or use the internet to look at maps, pictures, or to see any place discussed during the trial. Jurors must not have a discussion of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family member make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about the case by using an electronic device. You must not use computers or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. And these rules are imposed because jurors must decide the case without distractions and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I will have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That's contrary to our judicial system, which assures every party the right to ask questions about and to challenge the evidence being considered against it, and to present arguments with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result in would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, the defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. For the exercise of the defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that the defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it was made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had they been permitted to answer. And during the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little as your time is necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be up to you individually. You've been provided with a notepad and a pencil for your use if you wish to take notes. Any notes that you would take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of the notes and return to you when we reconvene. What we'll normally do is if we can take recesses, we'll just leave your pad. Generally, if you'll write your name on the outside cover and start the note taking, if you take it on the inside so that no one can see your notes. And then whenever we leave, we just leave it on your seat and we can come back and continue there. After you complete your deliberations, the bailiff will deliver your notes to me and they will be destroyed, and no one will ever read your notes. If you do take notes, don't get so involved in note taking that you become distracted from the proceedings. Your notes should be used only as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. With that, then we'll let Mr. Rapp, are you doing the opening statement?
Yes, Your Honor, I am. Thank you, Your Honor. May I approach the podium?
Yes, sir.
Thank you, sir. Good afternoon, all of you. Again, I'd like to echo the court and counsel and our appreciation for being here today. My name is Lawrence Rapp. I'm an assistant state attorney here in Collier County, and co-counsel to Ms. Mantorino today. We represent the state of Florida on behalf of your elected state attorney. We are filing this case against Mr. Nicholas Allen. Then take me to jail. Those were the words stated by the defendant, Mr. Allen, in this case, after Corporal Jason Booth of the Collier County Sheriff's Office asked him multiple times for his license and registration while Corporal Booth was conducting a traffic stop on the defendant. On Friday, January 17, 2020, Corporal Booth was on patrol in Immokalee, Florida at 3270 South 2nd Street. At that time, around 10 o'clock, he observed the vehicle coming down, traveling south on South 2nd, at what he believed to be the posted 30-mile-per-hour speed limit. Corporal Booth, concerned for pedestrians who were on the street and on the sidewalk, took his flashlight and flashed it at the vehicle coming down the street, driven by the defendant, in this case, Mr. Allen. As Mr. Allen approached Corporal Booth's location, Mr. Allen honked the horn a couple times at Corporal Booth and his partner, then passed them, turned his vehicle, and proceeded to back into a parking spot 3 or 4 spots away from Corporal Booth and his partner. Now at that time, Corporal Booth also observed that the tag lights on Mr. Allen's vehicle were inoperable. Mr. Allen parked his vehicle, got out of his car, and proceeded to walk across 2nd Street. Corporal Booth again took his flashlight, attempting to get the attention of Mr. Allen to conduct a traffic stop for the violations that he observed, both the speeding and the tag light, but was unable to do so. Mr. Allen continued to walk across the street. So Corporal Booth continued with his traffic investigation, went up to the rear of Mr. Allen's vehicle, began to take down the license plate, and at that time, Mr. Allen comes back across the street, now on the phone, where Corporal Booth again attempts to interact with him. We see your license, we see your registration. Today, you will hear testimony from Corporal Booth that after multiple attempts to get that information from the defendant in this case, to conduct this traffic investigation, the defendant refused, and refused. And even after being taken out of his vehicle for both officer safety and for the continuous refusals, and advised that his continued refusal would constitute an obstruction of the investigation that Corporal Booth was partaking in, the defendant's only response was then take me to jail. Never once did he give Corporal Booth his identification. Never once did he give Corporal Booth any information related to his vehicle. And that is why today, at the end of the testimony that you will hear at the end of this trial, the state will ask you to find the defendant guilty of resisting and obstructing an officer without violence. Since Officer Booth was an officer on January 17, 2020, that he was engaged in the legal duty of conducting a traffic stop, that the defendant knew he was an officer, and that the defendant obstructed Corporal Booth's investigation. At the end of all of that, we will ask you to return a verdict of guilty. Thank you.
Thank you, Your Honor. Please, the court, ladies and gentlemen of the jury, or counsel, everything that Mr. Rapp said was correct, with the exception of two things. Ladies and gentlemen of the jury, this is going to be either one of two things. Either this was a fishing expedition, or it was an overreaction to a simple question. Why are you stopping me? Why are you confronting me? What have I done wrong? But everything still was right. Mr. Allen was driving down the road, and you're going to hear from Corporal Booth an estimated speed, visually estimated speed of 35 miles an hour in a 30-mile-an-hour zone. You're going to hear that he did pull into that parking lot next to the police officers. He was going there anyway to go and talk to a friend. And as well, you're going to hear he walked across the street. You're also going to hear that after Corporal Booth shined that flashlight into the windshield at night, blinding him, Mr. Allen called the Collier County Sheriff's Office, dispatch, requesting a supervisor. He wanted, to lodge a complaint. Felt like he was being harassed. Then he sees 4 police officers get out of Rapp's license plate, look at his tag. He walks back, approaches his car. He does open the door. That's where his driver's license is in. And he says, what's the problem? You were speeding. They tell him. Like I was. I didn't think I wasn't supposed to shine that light again. I slowed down. Then they say, oh, plus your tag lights out. Oh, really? Can I take a look? No. Let me see your driver's license and registration. And then from there, it just escalated. He's like, okay, let me get it for you. He tries to go into the car. He didn't actually go into the car. You will hear evidence of that. To try and get his driver's license, and he gets yanked away. And at one point, he gets put into handcuffs, and he does provide his personally identifying information. His name, last name, date of birth. And he's in handcuffs at this point. However, he wasn't told that he was under arrest. Corporal Booth does go back to his car to run his checks, run through the database, discovers there's no warrant, discovers that his driver's license is valid, no issues, comes back, places Mr. Allen under arrest for opposing an officer because he asked a question. At the end of the day's trial, ladies and gentlemen, I think that you're going to come to the same conclusion that we're asking you to. This was a fishing expedition to turn up information. And we'd ask you to return a not guilty. Thank you very much. And again, thank you on behalf of all of us for your time.
Your Honor, the state, I do know we need to reposition the podium, Your Honor.
Yeah, can you do that?
I'm happy to do that, Your Honor. The state will be calling Corporal Jason Booth as the first witness.
Your Honor, may I approach the podium and clean that? Yeah, I didn't.
You raise your right hand, swear, please.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. I don't think anybody else here, we would be broken the rule, just in case. All
And may I inquire, Your Honor?
Yes, sir.
Thank you. Corporal Booth, can you please state your full name and spell your last name for the record?
It's Jason Booth, B-O-O-T-H.
And how are you currently employed, Corporal?
With the Coweta County Sheriff's Office, District 8 Road Patrol.
And how long have you been employed by the Collier County Sheriff's Office?
I've been employed with the Sheriff's Office since 2005.
And in what capacity?
I started in the jail. I did about 4.5 years in the jail. And then I went out to Golden Gate. From Golden Gate, I've since gone out to Immokalee. And I'm part of the Immokalee Special Enforcement Team.
And what are your general duties as a deputy sheriff with the Collier County Sheriff's Office?
As a deputy sheriff of the Coweta County Sheriff's Office, I answer calls for service. I also enforce the laws of the state and the county.
And you mentioned earlier that you were also assigned to the Special Enforcement Team. What is that?
The Special Enforcement Team, we do burglary, robbery, and drug suppression.
And were you on duty on the evening of January 17th, 2020?
Yes, sir.
And were you assigned to the set team that evening?
Yes, I was.
And what area were you patrolling that evening?
That evening, I was patrolling in the area of, I believe it was 327 South Second.
And is that in Naples?
Immokalee.
Immokalee. And that is in Collier County?
Yes, sir.
And were you in your standard gray CCSO uniform that we've all seen?
No, sir, I was not.
What were you wearing that evening?
I was wearing a CCSO tactical vest, a shirt, t-shirt, with either blue jeans or green BDUs.
And is that the general uniform for the assignment you were assigned to that day?
Yes, sir.
Is that the same uniform you're wearing today?
Yes, sir.
And on that evening, Corporal, did you come into contact with the defendant in this case, Mr. Nicholas Allen?
Yes, sir, I did.
And do you see Mr. Allen in the room today?
Yes, sir, I did.
Can you please identify him by pointing and describing the article of clothing that he's wearing?
Mr. Allen is in a black suit.
And Your Honor, for the record, let the record reflect that Corporal Booth did identify the defendant. And Corporal, you said that you did come into contact with the defendant that evening. Can you tell us how?
Yes, sir. I was standing outside of 327 South Second with my partner, and I saw a beige Toyota coming down the street at a higher rate of speed than the posted speed limit.
And did you interact with him after you saw him coming down the street?
Yes, sir, I did. As the vehicle approached my location, I put my flashlight on the vehicle.
Now, Corporal, based on the description of the area, do you think it would be helpful to the jury who used a demonstrative aid to potentially instruct the jury in where your position was?
Sure.
And Your Honor, without objection, may I guess just approach the well with the tripod. Thank you. And may the witness step down as well, Your Honor. Yes. Thank you. I know we're all spread out here a little bit, so I'm going to try and put this in the best position for everyone to see. I think that should be good. I know, I want to make sure that our friends in the newsroom can see this over there. Can everyone see this okay? Great. No?
Judge, we can't see back here. Oh, so I don't know if we
certainly don't have an objection to that transition.
If you get by the podium, maybe
one of our viewers was having a little difficulty.
Yeah, I mean, I can see Victor, but I don't see Louise.
Okay. Would it be helpful if I had the deputy explain the, apologies to interact with you, but would that be helpful?
Yes.
Thank you. And Your Honor, Corporal, we can approach.
Yes.
Thank you. Corporal, I'm going to community staff as well. That's okay. So, Corporal, you mentioned that what time of the evening was your interaction with the defendant?
It was about 10 o'clock.
And can you please show us what the blue tab where your location was?
It's gonna be on this side of the road at, I believe it's marked 325, so second. I was out near the roadway in the parking lot.
Thank you. And for the record, Your Honor, the witness has identified the location of what was previously stated. And with the red tab, can you please identify where on South Second you initially saw the defendant's vehicle?
Right about here, traveling southbound on South Second.
And why was it again that you recognized the defendant's vehicle coming down the street?
The vehicle appeared to be going faster than supposed to be limit.
And do you recall what that vehicle looked like?
The vehicle was a four-door beige Toyota.
And were there pedestrians on the street that day?
They were around the roadway.
Now, did you try and get the attention of the defendant in any way as you saw him coming down the street?
Yeah, as I saw him coming down the street, I flashed my flashlight at him.
And again, that's where that red flag is? Approximately.
The red flag is where I first noticed him.
Can you put another red flag where you believe the defendant was when you flashed your flashlight at him to get his attention?
Approximately right here. That's just as it approached my location on South Second.
And I just want to make sure that our witnesses over there can see it. Great, thank you. And Corporal, what happened after you flashed your flashlight?
After I flashed my flashlight, the driver honked his horn at me. Began to slow as he backed into a parking spot.
And again, with the red tab, can you identify where on there the defendant backed into?
Parking spot's going to be just south of my location, in the same parking lot. It's in front of 327 South Second.
And Corporal, you mentioned that you have been on the road since 2009. I know you said you did some time in jail.
Yes, sir.
During that time, have you had any training at detecting speed?
Yes, sir. I took a speed measurement training course for the week-long course.
And what does that entail?
It certifies you with radar, laser, and digital estimates.
And you said you visually estimated the defendant to be traveling above the speed limit?
Yes, sir.
What's the posted speed limit for that street?
That street posted speed limit is 30 miles an hour.
And what is the visual estimate that you believe the defendant to be traveling at?
35 miles per hour.
And after the defendant reversed into, or was reversing into the spot that you identified there just south of your location, did you observe anything on his vehicle?
I observed the vehicle, where your license plate is. It has a light that's supposed to illuminate the license plate. The light was out, you couldn't see the license plate.
And based on your training and experience, are vehicles required to have a tag light?
Yes, sir, there.
And when that vehicle, when the defendant's vehicle was backing in, were you able to read the license plate at all?
No, sir, I was not.
What happened after the defendant backed in?
When the defendant backed in, he got out of the vehicle. As he got out of the vehicle, I shined my light on him and tried to make contact with him. He proceeded to ignore me and walk across the street.
And what did you do after that?
As he walked across the street, he made contact with the crowd. I went to the rear of his vehicle to obtain the tag.
And what happened directly after that, after you went to go and look at the tag?
Immediately after I went to get the tag to the vehicle, he came back across the street. And I re-engaged him. Sir, can I have your license registration? This is a traffic stop.
So you were able to engage him at that point?
Yes, sir.
Did the defendant comply in providing you that information?
No, sir, he did not.
Why not? Why not? Did the defendant seem distracted at all?
He was on the phone.
And did you attempt to get his attention again?
Yes, sir, I did.
And did the defendant comply that time?
No, sir, he did not.
What did the defendant do after the subsequent time you attempted to gain his attention to provide his information?
He proceeded to sit down in his vehicle.
And did you ask the defendant again for the information while he was in the vehicle?
Yes, sir, I did.
Did he provide it to you then?
No, sir, he did not.
What did you do after that time?
Being that he's in a vehicle, I started to be concerned for my safety. I was concerned about him actually moving that vehicle. He has this whole area inside the vehicle. I don't know what's in the vehicle. I proceeded to grab him by his left wrist, and he complied and stepped out of the vehicle.
And at that point, did you inform the defendant why you needed the information you were requesting?
Yes, sir. I re-informed him that it was a traffic stop based on the speed tag light, and that he was required to provide me with his identification, license registration, name or date of birth.
And you asked for that information again?
Yes, sir.
Did the defendant comply at that time?
No, he did not.
Did the defendant make any statements to you at the time when you were interacting with him?
When I was interacting with him, the final time I requested it, I advised him that he was becoming obstructive, obstructing my investigation into a traffic stop, and that if I didn't obtain that information, he was going to subsequently be placed under arrest. At that time, he put his hand behind his back and taken me to jail.
And what did you do?
I placed him in handcuffs, and he was placed under arrest for obstruction.
Thank you. No further questions, Your Honor, and may the witness return to the witness box.
Yes.
Thank you.
Thank you, Your Honor. I do not. Good afternoon, Cooper. How are you?
Good, how are you, sir?
Good. No long down, won't take too much of your time. So you testified that you're a member of the SET team, correct?
Yes, sir.
And correct me if I'm wrong, but SET stands for Special Enforcement Team?
Yes, sir.
And there's 3 other letters associated with that, which are ACE, correct?
Not my group, District 8.
No, okay. Are there other groups within the sheriff's office that have the ACE or aggressive criminal enforcement?
Objection, Your Honor. Rollins.
In town, yes, in Naples.
All right. Now, you would agree that the Collier County Sheriff's Office has different units, such as the one that you stated you're a member of, correct?
Yes, sir.
There's a traffic unit, correct?
Yes, sir.
And there's regular road patrol, correct?
Yes, sir, there is.
Detective division.
Yes, sir.
And you would agree that even though as law enforcement officers, you guys can enforce all laws of the state of Florida, that these units typically focus on one area, correct?
I'm sorry, can you repeat that?
That even though all of the law enforcement officers of the Collier County Sheriff's Office can enforce all the laws of the state of Florida, when you're a member of a specialized unit, you typically focus on certain enforcement activities, isn't that correct?
Yes, sir, that's correct, sir.
So like the traffic unit is out there running radar, correct?
Yes, sir.
Okay. And the and you guys focus on, well, pretty serious criminal activities. And we do a good job about that. I'm sure you would agree with me, correct?
Sir.
Okay. All right, so I'll focus your attention now to what you and Mr. Rabb were talking about. You did say that you originally estimated him doing 35 and 30, correct?
Yes, sir, I did.
When Mr. Allen parked in that same parking lot where you guys were parked, he did so on his own, correct? He did so on his own, he pulled in on his own, correct?
Yes, sir.
You didn't direct him to park, correct?
No, sir, I did not.
So when he got, you testified that when he got out of his car, he began to walk across the street, correct?
He did begin to walk across the street, yes, sir.
Yes, once he parked, he began to walk across the street, correct?
He began to walk across the street, yes.
And he testified that you signed the light trying to get his attention, correct?
Yes, sir.
Okay, it's true that you didn't prevent him from walking across the street, correct?
No, sir, I did not.
And you testified that you informed Mr. Allen, in addition to the speed, there was a problem with the Cadillac that it wasn't illuminated, correct?
Yes, sir, I did.
And did he ask you to see what the problem was with the Cadillac?
Not that I recall.
No. You were able to get the tag number off the car, correct, when you went back there to look at it?
Yes, sir.
Okay. And did you run that tag?
I'm sure I did.
It came back to Mr. Allen?
I don't recall if it came back to him.
And you also testified that Mr. Allen was on the phone, correct?
Yes, sir, I did.
At some point in that interaction on that phone, either you or one of your partners took that phone away from him, correct?
Possibly.
Okay. When you went to go and put the handcuffs on Mr. Allen, did he resist in any way?
No, sir.
He didn't pull away?
No, sir.
He didn't tense up?
No, sir.
Okay. When you arrest somebody, as was this case, you search that person, correct?
Yes, sir, before they get into a patrol car.
And there was nothing found on Mr. Allen?
I do not believe so.
Mr. Allen's driver's license was valid?
Yes, sir, it was.
Objection, Your Honor.
Then just my final question, Corporal. You put in your report that you did give Mr. Allen a written warning for the tag light, is that correct?
Yes, sir.
Okay. But not for the speed, correct?
Yes, sir.
Yes for the speed or no for the speed?
I did not write one for the speed.
Okay. All right, that's all I have. Thank you, Corporal. I appreciate it.
Thank you, Your Honor. Corporal, Mr. Wilson asked you about the different units in the Collier County Sheriff's Office. You're assigned to a specific unit in the Collier County Sheriff's Office. Are you only to arrest people for certain offenses?
No, sir.
So, for example, if you were assigned to the traffic unit, you could still arrest someone for, let's say, murder.
Absolutely.
Okay. So nothing precludes you from your particular assignment from conducting any particular legal duty.
No, sir.
When the defendant got out of his vehicle, did you attempt to get his attention?
Yes, I did.
And how did you do that?
I shined my flashlight on him, and I asked him if I could speak with him.
And you stated the defendant went across the street at that point?
Yes, sir, he did.
Why didn't you follow him?
There's a crowd of individuals across the street, and I didn't want to cause any disturbance.
And Mr. Wilson asked whether or not the defendant resisted. Did he oppose your investigation?
He opposed my investigation.
Did he obstruct your investigation?
He obstructed my investigation.
And that investigation was into?
The traffic offense that was committed in my presence.
Thank you. No further questions, Your Honor.
Thank you, Corporal Luke. You may step down, sir.
Thank you, Your Honor.
Your Honor, the same rests in our case in chief. This is so wet up here, I'm not even sure I need to wipe it down. Nevertheless.
All right, ladies and gentlemen, I'm going to have you step back into the jury room. We will bring you out.
All right, jury, please.
Seated.
Yes, Your Honor, I'm going to move for a judgment of acquittal on a couple grounds. The first ground is that the officer was not performing a legal duty at the time of the events. Specifically, he would have the right to talk to Mr. Allen and to approach him and ask him for identification, but at the point he pulls him out of the car, he's exceeding that and it's illegal detention. There's no evidence, no testimony that he had any grounds for an arrest at that point. He claimed he was concerned for his safety, but there was no testimony or anything whatsoever which would justify that. For those reasons, at the point he is turning physical and pulling Mr. Allen out of the car, I think at that point, Mr. Allen's duty to give him any information is pretty much over. That ties right with the second part of the argument, is that there was no obstruction. Other than him just saying, yeah, I was obstructed, which was a conclusion, there's no evidence that he had any trouble getting Mr. Allen's information. He did say he believed that they ran the tag. There was no testimony that had trouble determining who Mr. Allen was, anything along those lines. The remedy for not producing a driver's license or a registration at the time of a traffic stop is another traffic infraction. It's not to then arrest him for obstruction. Based on those reasons, there was no evidence they had any trouble determining who he was, that in any way his actions slowed down them investigate. They'd already seen everything. They're just trying to figure out who he was. That's the only thing he could be obstructing at that point. There was no testimony that they had any trouble determining that.
Yes, Your Honor. Viewing the evidence most favorable to the state as a standard for judgment of acquittal, Corporal Booth testified that he was conducting a traffic investigation and that the defendant was pulled out of the vehicle because Corporal Booth believed, one, for officer safety based on the continued uncooperation, and two, that the defendant was going to move the vehicle that he was then in and drive away, based in part on that uncooperativeness. Corporal Booth also testified to the fact that he asked for the information multiple times, that at no point the defendant ever seemed cooperative in any way, and regardless of whether or not CCSO was able to run the tag, whether or not the tag came back and the vehicle registered to the defendant, the identity of the defendant and confirming that identity is still a critical element of any criminal investigation, including a traffic stop. And therefore, Your Honor, based on those facts, the state believes that the motion for judgment of acquittal should be denied.
Very brief response, Judge. There was no testimony that the vehicle was on or that anything other than him not responding verbally, that there was any justification for fear. I would also point out that there was zero testimony that they had any trouble determining who Mr. Allen was, aside from the fact that he wouldn't provide his identification.
Well, yeah, I mean, that seems to be the problem. They can run the car. Whether or not that's Mr. Allen driving it, but they were trying to get information. Without him cooperating and letting them know who it was, you know, who are they going to write a ticket to? An unknown person and just have them drive off. I think that does kind of obstruct the investigation by not cooperating with it. As to pulling him out of the car, I'm kind of surprised they actually let him back in. Just for their own safety, because you never know what's going to happen once that happens. So I think at this point in time, I would deny, based looking at all the evidence most favorable to the state, that there's been a prima facie case and deny your motion for judgment.
Thank you.
Thank you, Your Honor.
All right. My understanding is that Mr. Allen is going to testify, is that correct?
Let me make sure that it's still, yeah, yes, Your Honor.
Okay. Mr. Allen, you understand any evidence that's introduced comes in through your attorney, right? Okay. All right. Okay, and I'll bring the jury back and we'll go from there, right?
Before bring the jury back.
Your Honor, may we have a brief recess?
Sure.
All right. Oh, you're not there. Good reflex, John, I'm sorry.
you ready?
Your Honor, we're ready.
All right, jury's ready out.
Why don't we, yeah, 2 seconds, just clear. Clear mass, so they can see.
Okay. Jerry, you good questioning?
No.
Oh, all right, I wasn't sure. All right. Mr. Henry, you're
344 running back. All eyes for the jury, please.
Your Honor, the jury. Okay, seated. I have to tell you, one of your other duties, so you can't see it anyway, that little blue guy needs to be on all the way. Okay, Mr. Wilson, go ahead, sir.
Thank you, Your Honor. The defense calls Nicholas Allen.
Sir, if you would raise your right hand and be sworn by the clerk, please.
When you solemnly swear that while firm and that this will not be the shop explanation.
All right, good afternoon, Mr. Allen. Can you please introduce yourself to the juror and spell your first and last name for the record?
My name is Nicholas Rotunda Allen, NICHOLASALLEN.
All right, Mr. Allen, are you a resident of Collier County?
Yes, I am.
How long have you lived in the area?
Pretty much all my life, other than my stint in the military.
Okay. You say you were in the military?
Yes.
Okay, what branch?
U.S. Army.
Okay. And Mr. Allen, please tell the jury, what do you do? What do you do for a living?
I'm a disabled veteran.
And do you have family who live in this area?
Yes, I do.
What kind of family?
My mother and my father, and I do have brothers and nieces in this area.
Do you have any children?
Yes, I do.
You do? All right, Mr. Allen, have you ever been convicted of a felony?
Yes, I have.
How many times?
2 times.
All right, I'm going to take you back to the evening in question. Please tell the jury what it was that you were doing in that area.
Well, the day that I was on 2nd Street, I was there because I sell peanuts. I sell boiled peanuts to the football games and the Little League and stuff like that. Martin Luther King's birthday was on the 19th. I was coming up to get the permission from the property owner to come and do my peanuts for that day, the Martin Luther King Day. That's why I was there.
Was that, on that day, was that the first time that you were in that area?
No, I had been there 2 times, and when I encountered the officer, it was the 3rd time. Because I'm going to try to find the owner of the property. He wasn't there. I came back a 2nd time, and this was the 3rd time that I came back in.
All right. And then on those previous 2 times, did you happen to see anything that might have caught your eye? Or?
I saw those officers.
Okay.
I saw them standing up there, and in fact, the first time I came, I parked on the left side of them.
Okay.
And the last time I came, I parked on the right side of them.
Okay. All right.
And I drove down that street, both times that I came there.
All right. All right. And I think that it's pretty much, I mean, you would agree with the officer testified that he flashed the light in the car and all that?
Oh, yes, he flashed me.
What effect did that have on you, flashed the light?
Well, it blinded me. That's the effect, because I couldn't see anything. Once that light hit me, I hit my horn because I couldn't see anything.
Okay.
And I pulled up the car.
All right. Then what did you do after you parked?
I got out the car and I headed across the street.
Okay. Did you do anything else?
No.
Okay.
I was actually on the phone with dispatch because of the light being shined. I did call the dispatch
Okay,
to make a complaint.
all right.
So I was on the phone as I went and came back across the street.
Okay, all right. So then just explain to the jury what happened when you crossed back across the street. What did you observe?
Well, before I crossed back across the street, I asked about the owner of the property again. And one of the guys who I was talking to said, the police are behind your car. I turn around, I see them, I walk back across the street. I get to my car and I open up the door. And this officer who was up here pinned me in my car. One hand on the hood, one hand on the door. I couldn't move. And he told me it was a traffic stop. I didn't believe it because I had parked. I had walked across the street. I came up. So I'm like, really? And he's like, yes, this is a traffic stop. He kept getting closer and closer and closer until we were face to face. And he asked me for my ID. I said, what did I do wrong? He said, you were speeding. I said, how fast was I going? The other officer, not this guy, said at least 35. You were going at least 35.
All right, so it wasn't Corporal Booth that said that, was one of the other officers?
It was one of the other officers.
All right.
It was one of the other officers that flashed his flashlight. It wasn't this guy.
All right. And then what happened after that?
He started asking me for my ID. I questioned, what did I do wrong?
Okay.
He said, you were speeding. I said, how fast? He said, 35, at least 35. I said, you got on radar? He went immediately to the tag line. Oh, your tag is on.
Okay, so what happened after that?
I said, oh, really? I go to look at the tag, and like I said, I'm boxed in. I asked him to look at the tag. All I heard was license registration, license registration, license registration.
And where at this time was your license and registration?
Inside my car.
Okay.
And it's not my vehicle, but it's inside the vehicle.
Okay, all right. And you did have a valid driver's license?
Yes, sir.
Okay, and then what happened after all that?
That's when I felt myself being pulled away from the car because he had the license.
All right. So if I understand it correctly, I mean, you had the driver's license with you and all that, and it was a valid license, correct?
Yes, sir.
Okay. And they were asking for, suppose, give it to them?
Well, I had no problem with giving them the license. The problem I had was, why was I giving them the license? Because first I was told that I was speeding. I had a light shine in my face, first of all. Then I was told, you're speeding. You got a tag light, but you can't see the tag light. So I'm questioning because I've always been taught, hey, question, if you have a question, so you question.
All right.
And I questioned it.
All right. And then what happened after all that?
I never get a chance to see the tag light. We went back and forth a few times. I'm being pulled away from the car. He has my left arm. I'm yelling for the supervisor. Sergeant, your officer's got my arm. The sergeant turned his back, so he has his back turned to me. I'm trying to get his attention.
How many officers were there?
It was 4.
Okay, all right. And then, at any point, did you ever identify yourself, give him your information?
Yes, yes.
What information did you give him?
I gave him my name and my birth. Which was, that was the officer asked me.
Then what happened after this, I guess, yanking?
Well, before I give him my name and date of birth, while he had my hand, I'm yelling at the sergeant. He said, he's gonna let you go. Once this guy let me go, I said, I'm gonna get you this ID, Sergeant. His back is still trying to turn. I go return for the ID, I'm pushed up to the car and I'm handcuffed.
And by ID, you're referring to?
My driver's license.
Okay. At that point, when you were handcuffed?
I'm handcuffed.
So it's your testimony, you were trying to get them the driver's license?
Well, once he let me go, that's where I'm yelling at the sergeant who has his back turned to me. If you want this ID, here's the ID. I got this ID.
Right.
Because I've already questioned it so many times. If you want this ID, I'm trying to get it. I feel myself go up against the car. handcuffs to him.
When they put the handcuffs on you, what were you told?
I wasn't told anything, except, give me your name and your date of birth. And this was another officer, it wasn't this guy.
And then what happened after that?
I gave him my name, my date of birth. He gave it to the other officer. He went and ran. I'm sitting there in handcuffs.
How long would you say you were to stand there with the handcuffs?
Anywhere from 15 to 20 minutes.
Okay. And then what happened after he came back to you?
He came back and told me you were under arrest for obstruction.
Okay. Nothing else?
Nothing.
Okay. At any time did they search you?
Yes.
Okay. Did they search your vehicle?
I'm not sure because I was put in a car and I was taken away. My vehicle was open. So I don't know what happened after all.
Where were you taken away to?
The substation jail in Oahu.
Okay. All right. I've got no further questions, Mr. Allen. Thank you very much.
Thank you. Mr. Allen, good afternoon. When you backed into the parking space, you observed Deputy Booth along with other deputies near where you parked your car, correct?
Did I observe him?
Yes. When you were pulling back into the parking space, you observed the deputies.
Well, I really wasn't looking at him, but I had just passed, so I did see him. I just passed him and I pulled back in, no more than maybe 10 feet away from their vehicles.
Okay. So you knew the deputies were at that location?
Yes.
And when you got out of your car, Deputy Booth shined his flashlight at you, correct?
No.
Deputy Booth tried to get your attention?
No.
You just walked across the street?
Yes, I did.
And how long was it before you came back?
A matter of minutes, I would say 3 to 5 minutes.
And when you came back, the deputies were still near your car, correct?
They were coming from the back of the car.
Okay. And you were on the phone with the Collier County dispatch?
Yes, I was.
And you were requesting a supervisor?
Yes, I was.
And Deputy Booth was once again trying to get your attention. He approached you and said, I need to speak with you.
He was talking to me as I was talking to the dispatcher.
And Deputy Booth asked you for your driver's license, correct?
Once the phone was taken away from me, yes.
Once the phone was taken away from you?
Yes.
And you didn't provide Deputy Booth with your driver's license,
I asked him what was the purpose of the stop.
And Deputy Booth then told you that he was conducting a traffic investigation, correct?
He said it was a traffic stop.
And he told you that he visually estimated you speeding and also mentioned the non-functioning tagline, correct?
No, he didn't. The sergeant said I was speeding. I was going at least 35.
Okay. And Deputy.
Have the jury poll.
No, you're not.
All right, ladies and gentlemen, the jury, I want to thank you for your assistance throughout this proceeding here today. I know it was a long day for you. I will just read you one more instruction. I want to advise you that you have some special privileges enjoyed by jurors. No juror can ever be required to talk about any discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for their consideration of difficult cases. And we have recognized that your deliberations, discussions, and your votes should remain your privilege for as long as you wish it. Therefore, you may either disclose any issues that you wish, if someone wishes to speak to you about it, or you can tell them that you do not wish to speak about it. With that, I'm going to discharge you from their duties as jurors at this time. Also let you know that, and I think you were informed this morning, that you are exempt from jury duty for at least another year. With that, you'll follow Mr. Bell.
All rise for jury, please. Yes, we did.
All right, you may be seated. All right, now, I want to hear either the defense or the state in terms of sentencing, any recommendations.
Here I'm going to say recommend an adjudication, 15 days in jail, 6 months of probation, generally be done weekend or weekend lockdown, for cost prosecution.
Wilson.
He's going to be asking for adjudication of guilt, time served, a $150 fine, and as a mitigator, Mr. Allen is 60 years old. He is within the vulnerable population through this pandemic, and he does have significant family responsibilities, including his high school-aged kids and grandkids.
John, anything you would like to say to the court prior to sentencing? No, Your Honor. All right, then, Mr. Allen, the jury having returned verdict of guilty, the court is going to accept that. I am going to adjudicate you guilty. I'm going to impose a $250 fine plus court costs, to include the cost of prosecution and any public defender fees. It's on the cusp of almost, I don't want to penalize you for taking your case to trial, because I think there was a valid defense, or at least there was an issue that needed to be resolved. But Mr. Wilson raised an issue point, why go through all this if it was for a citation? You indicated you were with the Army. I'm sure during the course of your Army career, there might have been certain orders that you were given. I doubt very seriously that you questioned those orders. I would think you might want to apply that in your civility of life too. There are certain times where it's not worth it. There are also times where you have the opportunity to have another forum. So sometimes our hard-headedness gets in our way of our common sense. So other than that, I'm not going to let you anymore. I'm certainly not going to push you to jail on this. So that'll be the sentence of the court. I'll give you 60 days to fine and court costs. Other than that, if you cannot do it within that time, we can work out a payment plan with the clerk. Okay?
And Your Honor, the public defender's office is requesting $600 public defender fee.
And Mr. Allen, those fees, if you wish to have a hearing at another time, we can make a determination as to whether or not those are fair. If you do not wish to have that hearing, then I'll close the public defender fees in the amount of $600. What would you like to do? I would like to hear. Okay, we'll set that for a later point in time. Okay? Okay. All right. That. Next hearing, Dr. I want to say April 9th.
Your next hearing is
April 13th at 9 o'clock.
All right, so April 13th, 9 o'clock, we'll have the hearing on your fees, okay? All right, thank you.
Do you want to sign for that?
Yeah, please.
Can you take a look at the?
Oh.
Your Honor, to say excuse?
Yes.
Thank you.
Thank you.
Thank you all.
Thank you.
Mr. Allen, you can sit down, so we're ready to get your finger. You're good.
You don't want to show this. Okay, so we just leave it at 50.
12 hours. We were going to, I'm gonna be free.
Yeah, 150 is that.
We don't get it, so we don't care what you do. Well, it's in the application.
Yes.
I think, so if you want to check, we can. So good luck.